to NTD News Today.
Here are today's top stories.
The sentencing of President-elect Trump is currently underway in Manhattan. Chris Beers joins us from the New York State Courthouse, where the unprecedented event is taking place.
The highest court in the land will decide the fate of TikTok. The app is currently facing a deadline of January 19th to either shut down or find a new owner. More on the court's arguments happening today.
Devastating wildfires in Los Angeles have now killed 10 and destroyed thousands of homes. Meanwhile, the city's mayor faces questions over her handling of the crisis.
This is NTD News Today, live from our global headquarters in New York City.
Today is Friday, January 10th. I'm Stephanie Cox.
And I'm Don Ma.
An unprecedented day in American history. President-elect Trump is being sentenced in his New York criminal case as we speak.
NTD's Chris Beers joins us live from the New York State Courthouse in Manhattan. Chris, please describe the moment for us.
Guys, American history in the making. Right behind me, 100 Center Street, the New York State Courthouse, where Donald Trump is being sentenced right now as we speak. This is for the New York criminal case in which he was found guilty on 34 counts related to falsifying business records surrounding payments to adult film actress Stormy Daniels before the 2016 election. This is an unprecedented moment for a number of reasons. He's the first former president to ever be sentenced in a criminal case, as well as the first president-elect to ever be sentenced in a criminal case. And in just 10 days, Donald Trump will become the first convicted felon ever to enter the White House as president of the United States.
So Trump has been fighting this sentencing date, even though he likely won't face any penalty. The Supreme Court denying his request to have the sentencing delayed late yesterday. What happened with their decision?
Yeah, Steph, so Trump asked a New York appeals court, the New York Supreme Court, as well as the U.S. Supreme Court to delay sentencing in this case. That was on grounds that some of the evidence used was from his official acts as president. And as you know, the U.S. Supreme Court ruled just this summer that presidents do have some immunity from prosecution over official acts. He also argued that such sentencing would damage the office of the presidency. All of his requests were denied by all three of these courts, the latest being the U.S. Supreme Court late last night in a brief one-sentence statement, basically saying that he can appeal this conviction in the New York court system, so that it's not really necessary for them to rule on this, and also that because he's not expected to face any penalties here, it just doesn't matter because, the judge actually said that he wouldn't face jail time, he wouldn't face a fine or any kind of community service or anything in this. Again, this was a 5-4 decision with Justice Clarence Thomas, Samuel Alito, Neil Gorsuch, as well as Brett Kavanaugh dissenting.
And Chris, what's been Trump's response to the Supreme Court's decision?
Well, it's interesting. He said he thought it was a fair decision, saying, I respect the court's opinion. I thought it was very good opinion. And he cited the Supreme Court's path to appeal that they cited in the so that he could appeal in the New York State court system. And he said that he will appeal, calling this case a disgrace, guys.
All right, Chris, thank you very much.
President-elect Trump has lost a bid with a federal appeals court, as you just heard, to block the release of Special Counsel Jack Smith's report.
But even with the appeals court ruling, the report will not be released immediately.
A lower court ruling from Judge Eileen Cannon temporarily blocked the Justice Department from releasing the report. It remains in place for 3 days. The DOJ is appealing that temporary hold. Next, wildfires menacing Los Angeles have now killed at least 10 people and devoured nearly 10,000 structures.
5 fires burned overnight yesterday as dry desert winds fanned the flames. NTD's Daniel Monahan has the in-depth report.
The Palisades and Eaton fires already rank as the most destructive in Los Angeles history, consuming over 34,000 acres and turning entire neighborhoods to ash. Los Angeles County Sheriff Robert Luna says some have tried to exploit the tragedy, speaking on ABC News.
We had a number of looting arrests throughout the entire county region. That is unacceptable behavior.
At least 20 people have been arrested for burglary, looting, and other property crimes. Private forecaster AccuWeather increased its loss and damage estimate for the wildfires to up to $150 billion. Meanwhile, Mayor Karen Bass says officials are preparing to rebuild, but faces criticism for her handling of the crisis. A CBS reporter says he and his crew arrived shortly after the Palisades fire began, speaking on ABC News.
For several hours, we watched as hundreds of homes in a neighborhood burned to the ground. We did not see a single fire engine. We watched as Good Samaritans guided traffic. There was fear and there was a lot of confusion.
When lives have been saved and homes have been saved, we will absolutely do an evaluation to look at what worked, what didn't work, and to correct or to hold accountable any body, department, individual, etc. But my focus right now is on the lives and on the homes.
Los Angeles Fire Chief Kristen Crowley responded to whether the city had postponed testing its fire hydrants, speaking on ABC News.
The very dynamic situation of where we are currently with the wildland season, if you may, there was a decision to postpone. We did not, in regard to the January start date, we have all year to test them.
On Thursday, President Biden promised federal reimbursement for recovery efforts. In total, 5 wildfires burned across Los Angeles County. The largest, the Palisades fire, is just 6% contained, while the Eaton fire remains at 0%. Winds briefly dropped Thursday, allowing for crucial aerial support, but red flag conditions returned overnight. One blaze, the Kenneth Fire, erupted near Calabasas, expanding to 960 acres in hours. A suspect was arrested for that fire after being detained by community members. Schools remained closed Friday due to contaminated air. Residents have reported health issues, prompting some to wear masks.
The amount of smog and toxins in the air, it's like, you know, even though our house is spared, obviously we're probably not going to be able to move back in for months.
The EPA warns that fine particles in the air are linked to serious health risks. In brighter news, the Sunset Fire in Hollywood Hills has been fully contained, and a group of people helped rescue an injured dog they found near a house they were checking on.
It's about caring for each other. Like, everyone needs help right now.
The fires have impacted sporting events and other attractions. Universal Studios and Six Flags closed on Thursday, and the NBA postponed Thursday's game between the Lakers and the Charlotte Hornets in Los Angeles. Lakers head coach J.J. Redick also lost his house in the Pacific Palisades neighborhood of Los Angeles in the blaze. Daniel Monahan, NTD News.
Now to the southern United States, which is in the grip of a potent winter storm.
It has already impacted Texas, Oklahoma, and Arkansas as it moves across the region, bringing snow and freezing rain.
The system is forecast to move into Georgia today and produce a wintry mix, including sleet there. Transportation crews are gearing up by ramping up production of brine to treat roads and prevent ice buildup. Parts of Dallas saw 4 inches of snow yesterday. A portion of Interstate 35 in southern Oklahoma was also closed in one direction after a crash.
States of emergency have already been declared by governors in several southern states. The storm is expected to quickly blow over the country tomorrow morning, but not before bringing snow to the northeast later today.
President-elect Trump says he'll get the public some answers on the mysterious drone sighting spotted late last year, adding that he'll get to the bottom of it quickly. Trump was speaking at his Mar-a-Lago resort yesterday.
The Biden administration previously said they were a combination of lawful commercial drones, hobby drones, and law enforcement drones.
Next, an accused 911 9/11 mastermind will not be getting a plea deal to escape the risk of execution.
The Biden administration yesterday temporarily blocked Khalid Sheikh Mohammed from entering a guilty plea.
A 3-judge panel agreed to put a hold on the plea scheduled for today. In August, the federal government made a U-turn on plea deals its own Defense Department had negotiated.
Some families of 9/11 victims have been dismayed by the plea agreements because they would take away the possibility of a trial. Many see a trial as a key source of information, but some others believe plea deals are the best way for families to receive finality.
Vice President-elect J.D. Vance has officially resigned from his Senate seat. It will be effective this morning. The first-term senator had to give up his seat before he and President-elect Trump are sworn into office on January 20th. In a letter to Ohio Governor Mike DeWine, Vance wrote, "It has been a tremendous honor and privilege to serve the people of Ohio." It's now up to DeWine to appoint a replacement who would serve in the Senate until 2026 and a special election. The Ohio governor says he'll probably have an announcement next week. The Supreme Court is now hearing arguments over the TikTok ban.
Let's tune in.
Informed could be persuaded by Chinese misinformation. That, however, is a decision that the First Amendment leaves to the people. Given that the government's data security rationale cannot independently sustain the act, it is also grossly under-inclusive and ignores the most obvious, less restrictive alternative, simply banning TikTok Incorporated from sharing any sensitive user data with anyone. In short, this act should not stand. At a minimum, you should preliminarily enjoin it, which will allow you to carefully consider this momentous issue and, for the reasons explained by the President-elect, potentially moot the case. I welcome your questions.
Exactly what is TikTok's speech here?
TikTok, Your Honor, uses an algorithm that, in its view, reflects the best mix of content. What the act does is it says TikTok cannot do that unless ByteDance executes a qualified divestiture. That's a direct burden on TikTok speech, much less of a burden than the one that this court struck down in the Simon & Schuster case, where all the author had to do was take a certain amount of proceeds and put it into an escrow account for a short period of time to satisfy a civil judgment.
So why does a restriction on ByteDance, which is not a citizen, is not located in the U.S., a restriction on TikTok?
Because what the law says to TikTok is that TikTok, you cannot use the algorithm that you prefer to use unless ByteDance executes a qualified divestiture. So the law therefore falls directly on TikTok itself. It imposes a burden on TikTok speech, again, a much more significant burden than the one that was struck down in Simon & Schuster.
So you're converting the restriction on ByteDance's ownership of the algorithm and the company into a restriction on TikTok's speech. So why can't we simply look at it as a restriction on ByteDance?
Because I think the burden falls directly on TikTok, and I can use a hypothetical that helps illustrate the point. Suppose that China used its leverage over Jeff Bezos' international empire, including his Chinese businesses, to force the Washington Post to write whatever China wanted on the front page of the Post. Surely the government couldn't come in and say, Jeff Bezos, you need to either sell the Washington Post or shut it down. That wouldn't just violate Mr. Bezos' First Amendment rights. That would also violate the Washington Post's First Amendment rights, because they are ultimately the one that's suffering the burden under that law, because they have to go dark and close up their books.
Counsel, you began by saying this is a U.S. company operating in the United States.
Yes, Your Honor.
But the ultimate company that controls it, ByteDance, was found by Congress, and I quote this, to be subject to Chinese laws that require it to assist or cooperate with the Chinese government's intelligence work, quote, and to ensure that the Chinese government has the power to access and control private data that the company holds. So are we supposed to ignore the fact that the ultimate parent is in fact subject to doing intelligence work for the Chinese government?
Well, Your Honor, I don't think you are supposed to ignore that at all, but I also don't think that it changes the analysis for a couple of reasons. Look, TikTok and...
Well, just hold a second. Well, as I said, you began by saying this is a U.S. company operating in the United States, and it seems to me that you're ignoring the major concern here of Congress, which was Chinese manipulation of the content and acquisition and harvesting of the content.
Sure. And I'll start by saying that TikTok Incorporated is a United States subsidiary operating in the United States with its own set of free speech rights.
Do you dispute the fact that ByteDance has ultimate control of TikTok in its corporate organization?
Yes, Your Honor, I do dispute that, but I also don't think that it matters, because even if China could exercise overwhelming power against TikTok versus ByteDance, I don't think it would change the analysis. And I can take that Washington Post hypothetical and ratchet it up a little bit to help illustrate the point. Let's suppose that the Chinese government had actually taken the Bezos children hostage, and it was using that leverage in order to force Bezos and the Washington Post to publish whatever they wanted on the front page of the Post. So China effectively has total control. I still don't think that Congress could come in and tell Bezos either sell the Post or shut it down, because that would violate Bezos's rights and the Washington Post rights. Maybe what they could do is come in and say, you need to disclose the fact that you're under this amount of coercion, so that the people who are looking at the paper understand it and can make their own assessment. But I think the First Amendment rights of both Bezos and the Post would be directly implicated, notwithstanding that China in that scenario has effectively total control over what gets printed in the Washington Post.
Counsel, let me break this down. I understand your argument that there is a First Amendment right that the U.S. company has. I'll go that far with you, okay?
I'll take it.
Because we're affecting their ability to talk in whatever way they choose. The Washington Post could choose without any influence or threat against the children of Mr. Bezos to promote Chinese policy, and our First Amendment would permit them to do that if they chose it independently, correct?
Yes.
Now the question becomes, so it's not, that's just a given that they have a First Amendment right. The next question is, assuming they do, what's the level of scrutiny we apply? Isn't that what the issue here is?
That is certainly one of the issues, Your Honor.
All right. So if we get to that side of the issue, that TikTok USA has some sort of First Amendment right, taking your example, if the government said no speaker is free to speak under a criminal compulsion by someone else because of extortion, because of kidnapping, we are doing this because it is the only way to ensure the safety of people, that they are not going to be kidnapped or threatened, their lives threatened. You don't think that the government has a compelling state interest in saying, if there is a threat, a physical criminal threat against someone to do some activity, that the government couldn't say, I'm not questioning whatever the content is of that activity. I'm simply saying we, in our governmental powers, have a right to say, you can't do that. You can't speak.
Sure, Your Honor. So to take your question in pieces, I do think that they would have a compelling interest in that scenario to do something. But what I don't think is that they could simply target speakers in speech. Take, for example, generally applicable laws like the
So you think in that situation that the only thing the government could do is tell the Washington Post, disclose to the public that you are saying this because you are being forced to?
So
That's the only remedy the government could undertake?
No, Your Honor, but I want to make sure I understand the hypothetical. The compelling interest is in preventing this kind of compulsion, coercion, and ultimately harm to children. And I think that the government has a lot of different ways they can address that through speech-neutral laws. And I was going to point to things like the Trading with the Enemy Act or Russia sanctions. You can broadly say and attack problems.
They haven't been very effective.
Well, be that as
we're still having people kidnapped. We're still having coercion.
And be that as it may, you can say to Americans, you cannot collaborate with our enemies at all, and if you do that, you're going to be severely punished for doing that.
All right, we can go on to the effectiveness of the remedy, but the point is, I believe, that even if your First Amendment rights are impinged and there is some protection, the question is at what level of scrutiny?
Yes, Your Honor.
And whether that the action is content neutral or not.
I agree that that is the way that the analysis proceeds. Here, we believe that the level of scrutiny should be strict scrutiny.
What is the relevance of the history? Chief Judge Srinivasan, in his opinion, in the D.C. Circuit, emphasized that there is a long tradition of preventing foreign ownership or control of media in the United States, going back radio, television, and what have you. I would think no matter the level of scrutiny, that history has to be important, and I want to get your response to it.
I don't actually think it's important in this context because that history all arises in the context of bandwidth scarcity. And in that context, you have the government that's in the position of doling out a limited number of licenses. And when you have to dole out a limited number of licenses, you by definition have to pick winners and losers. And when you have to do that, you get a certain amount of discretion. I think that's the whole basis of those cases. You can't really take those cases
keep going.
You can't really take those cases and extend them to an area where there is no scarcity like the World Wide Web. Because once you do that, there's really no limiting principle. There's no reason why it wouldn't also apply to really popular books or magazines or newspapers or chains of newspapers. The bandwidth scarcity, I think, is really what justifies the greater discretion that the government gets in that area.
Mr. Francisco, let me see if I can break this down. Suppose that TikTok were outright owned by the People's Republic of China. Would you make the same argument?
I wouldn't be making the same argument, Your Honor.
Why not?
Because there you would have to confront a very different question, whether a foreign government that was speaking in the United States has First Amendment rights, and I don't know that the court has ever addressed that. But here we've got a U.S.
No, I understand that. I just want to see where you draw the line. So it's true, the court has never held that a foreign government has free speech rights. And if we were to hold that, I would think it would be because speech by a foreign government, particularly one with enormous resources, is not protected. Allowing that does not serve the underlying interests of the First Amendment, which are, among other things, fostering democratic self-government and furthering the search for truth. So let's assume that we start with that, all right? What if TikTok were then not owned by the foreign government, but it was undisputed that TikTok was totally controlled by the foreign government, could not do one thing without the approval of the foreign government? That's different?
I do think that it is different, Your Honor. For example, I've given the hypothetical that I've given, but there are a lot of companies in this country that have foreign owners, not just companies like Politico, which is German-owned, or Al Jazeera, which is partly owned by the government of Qatar.
Well, I understand that, but what would be the reason for drawing that line?
Sure,
if there's a good reason for saying that a foreign government, particularly an adversary, does not have free speech rights in the United States, why would it all change if it was simply hidden under some kind of contrived corporate structure?
Because it is a U.S. speaker. I'll give you another example. AMC movie theaters used to be owned by a Chinese company. Under this theory, Congress could order AMC movie theaters to censor any movies that Congress doesn't like or promote any movies that Congress wanted. And I think the reason is that here, where it's conceded, you actually have a bona fide U.S. company. It is not simply a Chinese cutout that is the Chinese government speaking itself,
all right,
but
let's
an
say that's
independent
not
United States company.
Let's say this is not a complete answer to to your First Amendment argument, but would you be willing to concede that this is a very important factor that should be taken into account in deciding whether there's a First Amendment violation?
Well, Your Honor, I think that it does help supply a compelling governmental interest, but I still think you have to march through the strict scrutiny analysis and analyze their interests. I do not think that they have a compelling governmental interest in the manipulation of content. I think that is in the teeth of the First Amendment, and if you look at the government's brief and the rest of the record in this case, that's really what it's focused on. Their complaint is the fear that the content could be critical of the United States government or could undermine our democracy. Yes, Your Honor.
Mr. Francisco, I just wanted to follow up on that line of questioning with just some fact questions, because it seems to me there are a couple of things that the parties still dispute about facts in this court, which is a little unusual. The government says that TikTok, U.S., has no authority or ability to alter the algorithm or recommendation engine, but must simply follow ByteDance's directives. You disagree with that in your reply brief.
Yes,
somebody has to be right and somebody has to be wrong about that. What does the record show?
Well, Your Honor, we are here on a record, and there is nothing in the record that says that TikTok, like any other subsidiary, doesn't have its own independent making authority. If you look at their record sites, what they point to is the ordinary types of control that a parent company has over a subsidiary company, but it doesn't change the fact.
All right, what is the fact? Are you prepared to make a representation?
Yes, Your Honor. The fact is that TikTok Incorporated, as a U.S. company, does have a choice over the algorithm. Now, it would be an incredibly bad business decision for them to abandon this algorithm, and they very doubtful would ever do it, but they have that authority. What they clearly have the authority to do is shut down the platform in the face of Chinese pressure. That's actually what they agreed to do in the National Security Agreement. I think that underscores why TikTok Incorporated as a U.S. company does have its own set of First Amendment rights.
Okay. And then another fact question. Before the D.C. Circuit, you argued that the Chinese government has made clear in public statements that it would not permit a forced divestment of the recommendation engine. Does that mean that some key component of the recommendation engine is under Chinese control?
No, Your Honor. What it means, and this might warrant a little more explanation, what it means is that there are lots of parts of the source code that are embodied in intellectual property that are owned by the Chinese government, and they would restrict, like the United States restricts the sale of those types of things to foreign governments. It doesn't alter the fact that this is being operated in the United States by TikTok Incorporated.
Okay.
So
I got it.
Okay.
I got it. And then you represent that the divestiture is not feasible within the Act's time frame. I'm sorry for these fact questions.
Sure.
But I just want to understand what's before us. Would it be feasible in any time frame? I take the government doesn't dispute that it's infeasible in the 270 days provided by law. But would it be feasible?
Your Honor, I think at least as we understand how they've interpreted the qualified divestiture provision, it would be exceedingly difficult under any time frame for two principal reasons. The first is that there's a global team of engineers that are some in China, some in Europe, some in the United States that maintain and update the original source code. And as we understand their interpretation, a qualified divestiture would prohibit any kind of coordination with that global team of engineers. The other reason is because, as we understand how they're interpreting it, a qualified divestiture would divorce the U.S. platform from the global content. So, for example, there are videos created in the United States. There are videos created in Ireland. In order to get global content, we need access to the Irish videos. They need access to the U.S. videos. We understand that couldn't happen.
Okay, so you think it's probably not feasible in any timeline?
Well, Your Honor, I think it'd be extraordinarily difficult.
Okay, last fact question, then I'll yield the floor here. The government admits that it has no evidence that TikTok has engaged in covert content manipulation in this country, but says that ByteDance has responded to PRC demands to censor content outside of China in other countries. Again, you deny that in your reply brief. Somebody has to be right about that.
Well, Your Honor, the problem there is everything that follows what you just read is redacted, and so I don't know what it says. What the record shows is two things. The record shows first what you just said. They haven't done anything here in the United States with respect to TikTok Incorporated. And second, the record also shows through our transparency reports that we haven't removed or restricted content on the TikTok platform in other parts of the world. And TikTok doesn't operate in China, it operates in other parts of the world. We haven't removed or restricted content at the request of China. That's what we put out in our regular transparency
removed
reports.
or restricted, though, doesn't necessarily cover covert content manipulation, though, right?
Well, Your Honor, I'm limiting my response to what's in the record.
Okay.
It's very difficult for me to respond to things that where I don't know what the accusation
I have other
is.
questions about the secret evidence in this case, but we'll get to that later.
Yes,
Thank you.
Mr. Francisco, can I ask you a question about the relevant speech here? So it strikes me that this is a little different than your Bezos example, because there it's clearly content discrimination because we're talking about the ability to post particular articles versus other articles. Am I right that the algorithm is the speech here?
Yes, Your Honor. Well, I would say it's, the algorithm is a lot of things. The algorithm has built within it, it's basically how we predict what our customers want to see.
The editorial discretion.
Yeah, the editorial discretion. It also has built within it the moderation elements. All of this kind of comes together when the source code is translated into executable code in the United States. In the United States, that executable code is then subject to vetting, review, moderation through content moderation algorithms, and so it ultimately lands on the TikTok platform.
But what we're talking about as a net choice is the editorial discretion that underlies the algorithm. And I just want to be clear, a lot of your examples talk about, including the Bezos one, the right of an American citizen to repeat what a foreign entity says, or say, I'm hitching my wagon to China, I want to say everything China does. Here, the concern is about the covert content manipulation piece of the algorithm. That is something that ByteDance wants to speak, right?
Well, Your Honor, I think that ultimately it's TikTok's choice whether to put it on the platform.
And you don't want that. Is your client disclaiming
we absolutely resist any kind of content manipulation by China at all. But what I do want to focus in on is what their asserted interests here. They do talk about covertness, but it can't possibly be that all they're concerned about is mere covertness. If all you were concerned about was the covertness untethered from the underlying content, that's something that could be easily addressed through a risk disclosure.
But that goes to scrutiny, the level of the application. Let's say that I agree with you the First Amendment is implicated, and I'm trying to figure out what level of scrutiny applies, and I'm trying to figure out what content, if any, discrimination is going on here. There's a disproportionate burden. Let's say that I agree with you about that. No one is preventing you. You're seeking access to a particular source code, engineering the recommendation feature. It's the technology that you want. You're not trying to repeat, as in the Bezos example, if we take the speech that the government's concerned about to be the covert content manipulation rationale, you're not seeking to utter that speech.
That's correct, Your Honor. What we are seeking to do is use an algorithm that displays the combination of content that we prefer our users to see on the platform.
And the government doesn't care about that. The government is fine with you doing that. You can invent it yourself. It doesn't even care what content that displays, cat videos or whatever.
Yeah, but I think that the way that the analysis has to unfold is first you ask, is this law burdening our speech? I think we agree that the law is burdening our speech. Then you have to look at whether the law itself is somehow content-based, not just what their motivations are, but whether the law is content-based. And here, the trigger for this law, the one thing that gets it going is if you operate a social media platform that has user-generated content, unless that content takes the form of a product, travel, or business review. Then within that universe of content, it says there's one speaker we're particularly concerned about, and we're going to hammer home on that one speaker. And then just to make the rubble bounce, they come in and tell us that one of the reasons they're targeting that speaker is because they're worried about the future content on that platform, that it could in the future somehow be critical of the United States or undermine democracy, to pull examples from the government's brief. So I think there's no way to get around the fact that this is a content-based speech restriction, and you do have to go directly to what their interests are. Now, their principal interest is...
I think I'm a little bit surprised by one of the answers that you gave to Justice Barrett. I had understood that TikTok's essential complaint here is that they wouldn't be able to use the algorithm that ByteDance has invented, and that they want to use the algorithm that ByteDance has invented.
100%. And if I was unclear on that, Your Honor, I apologize. That is absolutely
because I think
the core
what
of the
Justice
claim.
Barrett was saying to you is like, what's the problem here? Because ByteDance is a foreign company. Or maybe this isn't what Justice Barrett says, it's just what I say. ByteDance is a foreign company, and you started off with Justice Alito saying, you know, well, we would be making a different argument, and of course that's true. I mean, I would think that Alliance for Open Society makes it pretty clear that you have to be making a different argument with respect to a foreign state or a foreign company. So let's say that they don't have First Amendment rights. The only First Amendment rights lie in TikTok, which does have First Amendment rights. I guess my question is, how are those First Amendment rights really being implicated here? This statute says the foreign company has to divest. Whether or not that's feasible, however long it takes, TikTok still has the ability to use whatever algorithm it wants, doesn't it?
No, Your Honor, and their rights are implicated at a most basic level. In 10 days, TikTok wants to speak. In 10 days, because this law was passed, TikTok cannot speak unless ByteDance executes a qualified divestiture. That's not just ByteDance's choice. That is a condition that's imposed by law.
It definitely has effects on TikTok if ByteDance acts in the way that you are assuming it will act. So this is not to say that the First Amendment isn't involved, because TikTok is going to suffer some pretty severe incidental effects. But they are incidental, aren't they? Because the statute only says to this foreign company, divest or else, and leaves TikTok with the ability to do what every other actor in the United States can do, which is go find the best available algorithm.
Yeah. I very much disagree that the effects are incidental, because the way that this law works is it is only triggered if somebody is engaging in speech based on their content. User-generated content, except for business product and travel reviews. It then singles out a single speaker, and you have the concession for the government that one of the reasons they've singled out that speaker.
A lot of emphasis on the idea of just like, I think what you're basically saying is that all speaker-based restrictions generate strict scrutiny. I'm not sure that we've ever said anything like that. Let's put aside your argument that this is facially content-based. It seems to me that your stronger argument, or at least the one that most interested me, was this argument of, look, if the government is doing something specifically for the purpose of changing the content that people see, that has to be subject to strict scrutiny. But I don't see that as affecting TikTok, as opposed to as affecting ByteDance.
Well, no, I very much do see it as affecting TikTok, because they choose this algorithm because it reflects the mix of content. The government's fear is that China could come in and pressure TikTok, through ByteDance to TikTok, to alter that mix of content to make it too pro-Chinese or too anti-American. That is very much directly a content-based charge straight at TikTok. The other point I would like to...
I hear you that it might very well have that effect. I guess what I'm suggesting is that the law is only targeted at this foreign corporation, which doesn't have First Amendment rights. Whatever effect it has, it has. Maybe ByteDance will figure out a way to put this on open source, and then TikTok will be able to use the algorithm.
So, Your Honor, if I could take that on directly, because I think TikTok has First Amendment rights. To the extent ByteDance is speaking in the United States, it, I believe, has First Amendment rights. If you conclude that neither has First Amendment rights, then surely the creators have First Amendment rights. But if you take a step back, what their position is is that none of these entities, this is the universe of entities affected by this law, none of these entities have the authority to assert First Amendment rights, which means that the government really could come in and say, I'm going to shut down TikTok because it's too pro-Republican or too pro-Democrat or won't disseminate the speech I want, and that would get no First Amendment scrutiny by anybody. That cannot possibly be the case, yet that is the effect of their position. The last point I'd like to emphasize, though, is this law, like the Playboy case, like the Hobby Lobby case, has built within it a less restrictive alternative, which is the general provision, by definition designed to protect against the very harm the government is identifying. Suppose New York State passes an asbestos abatement law. They say these types of buildings have to abate asbestos. In addition, New York Times, you have to abate asbestos in your building, and they say there are two reasons for this. One, we want to abate asbestos. Two, we hate the New York Times editorial page. Surely, at the very least, what you're going to say is you can't target the New York Times directly. What you can do is throw them into the general process.
Thank you,
we think that's the minimum that should be done here.
Thank you, Counsel. We've been talking about connection between the regulation of TikTok and the burden on expressive conduct. And your basic position is that interfering with the ownership of TikTok constitutes a direct regulation of the expressive conduct of other people. What is your best example in our precedent of a situation where a regulation of corporate structure or something else has been treated as a direct regulation of expressive conduct?
The regulation of a corporate structure as Your Honor, I don't have a case at my fingertips. I can consult.
Well, I don't have one at my fingertips or any other
rebuttal, but I think it's quite clear, though, that if you're saying to a company, you have to stop talking unless somebody else does something, and that's imposed by the force of law, it directly affects that company's speech.
Well, it's again, I don't know if it's directly affecting the company's speech or the speech of third parties, and I'm not sure what, where your emphasis is. But again, I'm not sure there's another case where we've said that regulating a company others' expression should be treated as direct imposition on their speech in terms of the standard of review, for example, when it's based on derivative regulation of corporate structure of somebody else.
Well, Your Honor, I think that it's, I would concede that this is a pretty unprecedented case. I'm not aware of any time in American history where the Congress has tried to shut down a major speech platform. But I think that if a law imposes a direct regulation on a third party, that in turn results in shutting down somebody else's speech, and they do it for content-based, viewpoint-based reasons, and in particular on this record, because the speaker that is ultimately being shut down, they don't like the speech of that particular platform, that's a real problem.
So it may be a real problem or may not, but I just am wondering if there's any precedent where we have that same connection and that it affects the standard of review, for example. You would treat it as a direct restriction on expression. Even the only thing the law does is say, in this case, somebody other than the Chinese government has to own it.
So we don't have any direct precedent along the lines that you're citing, but we do have precedents. We have cases like ACARA, and what ACARA says is if the law is totally speech neutral, then that's one thing. We have cases like O'Brien, which say if the law doesn't care about speech but happens to draw in speech, that's another thing. Both of those cases make clear, however, is that when the law is concerned with the content of the speech, when the justification is based on the content of the speech, that's cases like Reed 2, then you do trigger strict scrutiny.
So then I think your argument comes down to, is this direct concern with speech, or is it concerned with the potential for Chinese interference with the level of interference indirectly? In other words, they're not coming back. The Chinese government, TikTok, doesn't care what the people are saying on TikTok. That's not the concern. The concern is that they are regulating a particular channel of communication. And I just wonder if there's any precedent for that type of thing. They're not saying we're going to restrict this content and that content, but not this. They're just saying we're going to be in a position where we can control what happens, whether it's based on expression, whether it's based on anything else.
So, Your Honor, I disagree. And I think if you take a step back and look at this record, I think it is quite clear that it is focused on both current and potential future content on TikTok Incorporated. Here, you don't have just an act that is based on speakers and speech. It's triggered by speech. It's focused on a single speaker, TikTok Incorporated.
Justice Thomas, anything further? Justice Alito?
What if Congress, if there were nothing in this act about content moderation or covert manipulation, what if it was just about preventing what Congress viewed as an enormously powerful, popular application from gathering an arsenal of information about American citizens, and they said this is the worst offender and we're going to require divestiture by this offender. Would there be a First Amendment problem there? And if you think there would be, what would the level of scrutiny be?
Yes, there would be a First Amendment problem if you had a law like this that was only focused on speakers, those who use user-generated content other than product, travel, or business.
Well, Congress concludes that this particular entity is the worst. This is the worst offender, and it happens to be an entity that is involved with speech.
If all you had, so I want to make sure I understand the hypothetical. The only provision you have is one that says this company has to shut down because of data security.
Right.
I would have a different set of arguments. I think it would still implicate the First Amendment, particularly where you have strong evidence that they were being targeted in part, at least because of their speakers and speech. Suppose Congress passed the law that you posited.
But you're changing that. You're changing the hypothetical by injecting congressional concern about the
Okay, well, I'll put that to the side.
So what would your argument be? It would be an equal protection argument?
No, I'd still be saying that ACARA itself makes clear that where a law disproportionately burdens just a speaker, we have to subject that to scrutiny to suss it out, to suss out whether the asserted interest is the actual interest. There, the asserted interest is in data security. I think I would have a couple of arguments under whatever form of scrutiny you wanted to apply, whether it is strict scrutiny or intermediate scrutiny in that context. I would say first that law is dramatically under-inclusive because it categorically exempts e-commerce apps that this record shows have comparable ties to China.
You say, I don't want to prolong this too much. You say this is not like ACARA, I think primarily because you say that the divestiture requires the new company to cease using the algorithm, right?
No, I think it's not like ACARA for a much more fundamental sense. ACARA involved a totally speech-neutral law. It didn't go after speakers at all. If you had a law in ACARA that said we're going to prohibit prostitution in bookstores only, then I think that ACARA would have come out differently. There would have at least been, some kind of intermediate scrutiny, potentially strict.
All right, well,
that's the law that I think is your hypothetical.
Walk away from the hypothetical that I posed for the purpose of narrowing in on what your argument is. I understood you to say that that would not be a solution to the problem because one of Congress's motivations was based on the content of TikTok. Am I wrong in that? Did I read your argument incorrectly?
Well, I think that I want to make sure I understand what you're saying. I certainly think that because one of the motivations was content, that is an enormously important fact. I was trying to answer your hypothetical where we were trying to take that out of the mix. And the reason why ACARA is different is because ACARA didn't just simply say no prostitution in bookstores. That's what your hypothetical effectively says. It says no data security problems in speakers or in this particular speaker. And I think that would trigger, at the very least, intermediate scrutiny.
All right, thank you. Thank you.
Justice Sotomayor?
That goes to my question, which is, Justice, the Chief Justice asked you whether or not we've ever had a case where pure ownership was at issue and not speech. And I don't think we've had one like that, you're right, but I don't think that the question gets to the essence of your argument, is it? The essence of your argument is you're being asked to divest because of speech, correct?
Correct.
All right. So if I get past that, if I go to Justice Alito's point, which is I don't think it's just about speech, it's about data control. If it's about data control, and assume, for the sake of argument, that I believe intermediate scrutiny applies to the data control provision, then your arguments would be different, wouldn't they? They would be under inclusiveness, they would be other arguments, correct?
Well, Your Honor, I think they'd be very similar because I think the nature of our arguments work just as well under intermediate and strict scrutiny. If I could unpack that a little.
No, I'm not going to,
Sure.
because we're going to run out of time, because we're going to need to figure out what intermediate scrutiny means. But I'm not sure it means what you do, which is I don't think any of our cases have ever suggested that we have to use the least restricted means under intermediate scrutiny. In fact, our cases have said we have to use a reasonable means.
And if I could respond to that point specifically, I completely agree it's not a least restrictive means alternative, Your Honor. But you do have to at least consider alternatives. Here, if the concern, let's take the data security concern, which you put your finger on.
I know you want to keep going on, but I can't let you, because I can't monopolize the argument, okay? But let me just get to the bottom of that, all right? You seem to suggest that Congress has to actually look at all of the alternatives and say no. I don't think we have a case that says that.
I am not
If from the record it's clear that alternatives won't be adequate for whatever set of reasons, isn't that enough?
If the record were clear on that, that might be enough.
Now
But
I take
here
that.
on the
Now let me
key-
go to the next question and the last.
If I could, Your Honor, just one sentence. If on the key, less restrictive alternatives, they had actually considered them and said what you suggested, this would be a different case. But our point is that on the key, most obvious, less restrictive alternatives, a law, for example, that simply prohibits TikTok Incorporated from sharing any sensitive user data with ByteDance or anyone else, there's nothing in the record that suggests they even considered it. And that's why it would fail under even intermediate scrutiny.
We have a different problem, which is that the record shows that there is no sharing that could happen that wouldn't put the data at security. But we can go past
That's incorrect, actually.
No, because the NSA doesn't.
I'm not talking about the NSA.
Or even anything else. But putting that aside, one last question. Assuming that the covert manipulation issue is one, I think that what remains is, to the Chief's question and Justice Alito's questions, if the covert manipulation is a concern, then the question becomes what kind of burden does it put on TikTok USA? And I think your point is that that requires strict scrutiny because it doesn't permit them to speak to the Chinese government through the algorithm and promote whatever speech it wants to promote through the algorithm, correct?
It doesn't permit them to speak to the American public through the algorithm.
Right.
And promote whatever type of speech they want to promote on the algorithm. And I also think that this covert manipulation is a little bit odd. They're not concerned just with covertness. If all you were concerned
I'm going to
with
ask
was secret.
Xi about that. How do you disentangle the two things?
Thank you, Your Honor.
Justice Kate? Justice Gorsuch? Justice Kavanaugh?
Just on the data collection interest, I think Congress and the President were concerned that China was accessing information about millions of Americans, tens of millions of Americans, including teenagers, people in their 20s, that they would use that information over time to develop spies, to turn people, to blackmail people, people who a generation from now will be working in the FBI or the CIA or in the State Department. Is that not a realistic assessment by Congress and the President of the risks here?
Well, Your Honor, I'm not disputing the risks. I'm disputing the means that they have chosen. One way, the most direct way to address that, all of this user data sits on data servers in Virginia controlled by Oracle. I'm not talking about the National Security Agreement. What I'm talking about is a law that simply says to TikTok Incorporated and its U.S. employees, you cannot share that user data with anybody. You can't give it to ByteDance, you can't give it to China, you can't give it to Google, you can't give it to Amazon, you cannot give it to anybody under threat of massive penalties. They never even considered that most obvious alternative, and so whether you apply intermediate scrutiny or strict scrutiny, it's not a least restrictive means test, but you gotta at least consider the most obvious alternative.
So you acknowledge the risk that Congress and the president were concerned about. You're just saying the means they chose to address that risk were incorrect,
so
not permissible.
I certainly acknowledge the risk, but I think there are lots of reasons, not just the one I just gave, but there are lots of reasons why that risk still can't justify the law. When it sits alongside of the impermissible covert manipulation risk, I think it falls under Mount Healthy. It's no different if they came in and said, we passed this law, one for data security.
I understand that, but just on the data collection, that seems like a huge concern for the future of the country.
And Your Honor, again, it is a concern, two responses. First, it is a concern that can be addressed directly. The reason why there's no evidence in this record about whether that kind of direct prohibition on TikTok Incorporated from sharing sensitive user data with anybody, including ByteDance, the reason why the record is devoid of any evidence of that is because Congress never considered the other side of the balance. And that's the minimum that Congress has to do under the First Amendment. It's got to at least consider the consequences of shutting down a speech platform used by 170 million Americans against the benefits of an alternative, like simply saying to TikTok's employees, you're essentially going to get massive fines, potentially jail sentences, if you share any of that sensitive user data with anybody. Not TikTok, not ByteDance, not China, not anybody else in the world. Yet there's nothing in this record that suggests they even considered that alternative.
What happens after January 19th if you lose this case? Can you just spell that out?
At least as I understand it, we go dark. Essentially, the platform shuts down.
Unless there's a divestiture.
Unless there's a divestiture, unless President Trump exercises his authority to extend it by night, but he can't do that on January 19th. On January 19th, we still have President Biden, and on January 19th, as I understand it, we shut down. It is possible that come January 20th, 21st, 22nd, we might be in a different world. Again, that's one of the reasons why I think it makes perfect sense to issue a preliminary injunction here and simply buy everybody a little breathing space. This is an enormously—
What do you mean by shut down, too? Can you just spell that out?
So,
if you
the app is not available in the app stores. That's at a minimum. But in addition, what the Act says is that all of the other types of service providers can't provide service either. Now, there's enormous consequences for violating that for the service providers. So essentially, what they're going to say is that, I think we're not going to be providing the services necessary to have you see it. So it's essentially going to stop operating. I think that's the consequence of this law, which again is why a short reprieve here would make all the sense in the world. It's an enormously consequential decision, and I think all would benefit if it weren't necessary.
Thank you.
Justice Barrett.
So I just want to, it's kind of following up on Justice Kavanaugh's questions. Let's say I agree with you that some level of scrutiny applies, and I'm trying to figure out which level of scrutiny applies, and I'm trying to figure out if there's content discrimination. And let me ask you different question than I did before about the algorithm. I mean, you keep saying shut down. The law doesn't say TikTok has to shut down. It says ByteDance has to divest. If ByteDance divested TikTok, we wouldn't be here, right? If ByteDance was willing to let you go and willing to let you take the source code with you, that would be fine, right? We would not be here.
Well, Your Honor, if ByteDance divested, then the law wouldn't fall on TikTok. But the law, not ByteDance.
But that's because of ByteDance's choice, right? I mean, this is like Justice Kagan's point. I mean, I'm trying to figure out how we account for the reality of third-party choices and the choices of third parties that the whole reason for the law being passed in the first place.
Yeah, Your Honor, I still don't, I think that the way the analysis works is step one, is there a First Amendment violation?
right?
Step 2, you get to the question that we're grappling with. What standard of scrutiny do you apply? Typically, what you do is you ask, is this law content-based? Is it content-based based on its face? Is it content-based in its decision? Here, we know it's content-based on its face because it says what it says. We know it's content-based in its motivation because the government concedes it's content-based in its motivation.
Well, that's not quite what I'm asking. I mean, let's see, that's the dispute between you and the government. Is it content-based if it's about divestiture and not about telling TikTok what content it can display on the platform?
And I think it has to be because I think that really goes to the first question. Does the burden fall on the speaker? If the burden falls on the speaker, that triggers the speaker's First Amendment rights. But the law is, in fact, content-based, whether it comes in the form of a divestiture or something else. When the law specifically says it's content-based, we're worried about the content on the platform. And when the government tells you that one of our reasons, one of the things that we're worried about is TikTok, not ByteDance, but TikTok Incorporated and TikTok in the United States will, absent the divestiture, have a mix of content that we find objectionable. They will mix around their videos in a way that is too pro-Chinese or too anti-American, and that is TikTok, the platform.
Let me just ask you one last question. Why is it impossible to divest in the 270 days, even assuming that the Chinese government hadn't said you couldn't?
Sure, and this is the exchange I was having with Justice Gorsuch. There are two basic reasons. The first is that the underlying source code, that's the source code that comes in here and then has to be converted.
But that's what Justice Gorsuch said, just not ever. So it's not really that you can't do it within the time frame. It's that you really couldn't ever divest because you never are going to get the source code.
Well, let me unpack that a little bit. No, it's that with the underlying source code, it takes a team of engineers to update and maintain that. It would take us many years to reconstruct a brand new team of engineers to do that with respect to the source code. With respect to the sharing of content, that was the different reason. In theory, we could kind of send our salesmen around the world, go to Ireland, go to Finland, go to every country and say, look, you used to automatically get our content, but now you got to separately sign up for our platform.
Last point, let me make sure I understand what you're saying. It's not that you couldn't execute the disentanglement. You could say, we're independent. You just can't recreate TikTok in any kind of way.
Well, I think that any new TikTok would be a fundamentally different platform with different content, which is yet another reason why I think this is a content-based restriction that falls directly on TikTok Incorporated itself in our platform.
Justice Jackson?
So I guess I'm back to some of the questions that Justice Barrett and Justice Kagan asked about the sort of threshold issue that you point out, which is there a burden on the speaker? I'm trying to understand what the burden is that you are articulating and whether it really isn't about association and not speech. You say you have in your brief some cases that talk about American speakers being free to choose whether to affiliate with foreign organizations, and the colloquy you had with Justice Kagan made me think that what you're really complaining about is the inability to associate with ByteDance and its algorithm. That it's not really about, if TikTok came up with its own algorithm or bought an algorithm from some other company or devised it or whatever, this law would have nothing to do with them from your perspective. But the problem I think you're articulating, and this is, I'm seeking your clarification.
Sure.
The problem I think you're articulating is that you want to use ByteDance's algorithm and therefore associate with ByteDance, and Congress has prohibited that by requiring divestiture. So isn't this really a right of association case under the First Amendment?
I think it's both, Your Honor. I do think that that is a component of it. We want to use the algorithm that we think reflects the best mix of content. That's the algorithm that reflects the best mix of content. What this law says is we can't do that unless ByteDance exercises a qualified divestiture. But I also think more directly what this law does is it says to TikTok Incorporated, if ByteDance doesn't exercise a qualified divestiture, you have to go mute. You cannot speak at all.
No, I don't think it says that, though. I mean, if TikTok were to post-divestiture or whatever, pre-divestiture, come up with its own algorithm, right, then when the divestiture happened, it could still operate. It doesn't say TikTok you
I
can't
think that's
speak.
theoretically correct, Your Honor, but
Right,
I think that
but
also underscores the content-based nature of the restriction.
No,
We have
but
to
the
change our
the
speech.
fact that that's true suggests that you're wrong about the statute being read as saying TikTok you have to go mute. Because TikTok can continue to operate on its own algorithm, on its own terms, as long as it's not associated with ByteDance. So isn't this really just all about association?
Your Honor, I think it is partly about association, but I'm going to take another shot at explaining why it's not just about association.
Okay, well, let me just take you down the association path for a second, because if it is about the association of TikTok with ByteDance, then don't we have cases that seem to undermine your view that Congress can't do this? I mean, I thought we had cases about Congress prohibiting association with terrorist organizations, prohibiting association with foreign adversaries. And so why doesn't this fall into that kind of group of our jurisprudence?
Well, at least as I understand all of those cases, they applied strict scrutiny. The material support statute most definitely applied
and ultimately upheld the law, so fine.
But sure, and I think if we go down the strict scrutiny road here, I don't see that this law can possibly be satisfied under the interests that they assert here. But I do want to emphasize why this is also about TikTok speech. Even under your hypothetical, where theoretically they can say something differently than they are saying today, that in and of itself is a direct restriction on TikTok speech. They can't engage in the speech they want to engage in. They have to engage in a different kind of speech, the speech they don't want to engage in. That is a direct burden on TikTok incorporated speech.
All right, I think I understand that argument. Let me ask you a question about your colloquy with Justice Kavanaugh. Did I understand you to concede that there is a compelling interest and that the problem is really tailoring? I mean, you said, I understand the risks. I don't hear you suggesting that the risks don't exist. So it sounds like we've gotten past, even if we're in strict scrutiny world, we've gotten past the compelling interest part of this.
No, Your Honor. What I was saying is that all you had standing alone were the data security. That would be a different case. Here, when you have the content manipulation sitting right alongside of the data security, that taints the data security rationale. If Congress came in and said, we're passing this law for two reasons. One, we really care about data security, and two, we hate the speech on TikTok. The data security wouldn't alone sustain that law under cases like Mount Pleasant.
I understand, but why you're equating we don't want foreign adversaries to be able to manipulate the content on this platform. You're equating that with we hate the content, and I'm just trying to understand why.
Because content manipulation is by definition a content-based distinction. Look, everybody manipulates content. There are lots of people who think CNN, Fox News, the Wall Street Journal, the New York Times are manipulating their content. That is core protected speech. That's why they put so much weight on this mere covertness.
Right, but that analysis is just about content-based versus content-neutral, and therefore whether you apply strict scrutiny. I'm in the strict scrutiny world, okay? I'm assuming that you're right, that strict scrutiny applies, and now prong number one in that world is, does the government have a compelling interest? And so I'm trying to understand why the government's argument that we have data manipulation concerns, which I understood you in colloquy with Justice Kavanaugh to say is a risk, and we are concerned, based on what Justice Gorsuch says when he's looking at the facts, that the government contends that there's this real problem with this foreign adversary doing manipulation in other places. Are you saying those are not compelling government interests?
I am 100% saying that content manipulation is not just not a compelling governmental interest, it is an impermissible governmental interest. You could not go to CNN or Fox News and say, we're going to regulate you because you're manipulating the content in the way that we don't like. That is per se impermissible.
Okay, can I just ask you one last thing? You say, with respect to the tailoring issue, that disclosure, you think, is a possible, more narrowly tailored way of handling some of this. And I guess I'm just wondering whether disclosure under this court's case law and the law of other lower courts doesn't carry its own First Amendment complications? That wouldn't we have compelled speech problems if disclosure was required in this situation?
Sure, Your Honor. Now, look, I might think so because I think that the factual predicate is wrong, but they think the factual predicate is right. And if the factual predicate is right, then there are no First Amendment problems at all under Zauder and the cases that you're suggesting. And that underscores the larger problem here. Not all disclosures are perfect. I'm not here to argue that they are. But you've always got to consider what the alternative is. And here the alternative is shutting down one of the largest speech platforms in America. The reason there's no evidence in this record as to disclosures is because Congress never even undertook that balancing in the first place.
Thank you.
The bare minimum that has to be done before we take an unprecedented step of shutting down the voices of 170 million Americans.
Thank you.
Thank you, counsel. Mr. Fisher?
Mr. Chief Justice, and may it please the court, wholly apart from the company's legal interests here, the Act directly restricts the First Amendment rights of American creators to participate and speak in what the court a little less than a decade ago called the modern public square. And what you might say today is the most vibrant speech forum in the United States of America. And the Act, therefore, is inescapably subject to strict scrutiny because of the First Amendment implications. And the Act fails that test, and indeed any level of scrutiny under this court's case law, because the Act and the reasons behind it defy our history and tradition, as well as precedent. American creators have long and always enjoyed the right to speak in conjunction with foreign speakers or work with foreign publishers. Americans even have the right under the Lamont case to receive information from foreign speakers, indeed foreign governments. So that leaves the government with this implication and its use of the phrase national security in this context. But that just simply doesn't change the calculus. Throughout our history, we have faced ideological campaigns by foreign adversaries. Yet under the First Amendment, mere ideas do not constitute a national security threat. Restricting speech because it might sow doubt about our leaders or undermine democracy are kind of things our enemies do. It is not what we do in this country. And so we think the court should reverse, and I would welcome the court's questions.
How exactly are the creators' speech being impeded?
So two ways, Justice Thomas. First, I just point you to the text of the statute, which directly regulates text, images, real-time communications, videos. My clients, the creators, are the ones creating that speech and posting it to speak to other Americans.
But it doesn't say anything about creators or people who use the site. It's only concerned about the ownership and the concerns that data will be manipulated or there will be other national security problems with someone who's not a citizen of this country or a company that's not here.
So there's two ways, and I think the Sorrell case is where you look for the analysis of the First Amendment burden here. As I said, the text of the statute regulates our speech, and then you point out ownership, and this was talked about a lot in the first part of the argument here, so let me be very clear. The American creators have a right to work with the publisher of their choice. So imagine somebody wanted to work on post speech on Twitter, now known as X, and Congress passed a law saying, we don't like the current owner of X. The current owner of X has to sell that platform or else it has to shut down. People who post on that platform and who indeed some of them make a living commentating, engaging on current events, news, politics, would have a First Amendment claim to work with
using that argument,
publisher.
you could have said that about the breakup of AT&T. You could say that about the foreign limitations on foreign ownership of broadcast companies.
Well, no, I think that you have to dig a little deeper than that, Justice Thomas. It's not mere foreign ownership, and it's certainly the broadcast cases I'll get to in a moment, but it's foreign ownership because of a particular perspective. If you boil it down to an essence, the owner of a print media or online media publication is the essence of the viewpoint of that publication. The current owner of X or the current owner of Fox News or the current owner of MSNBC has a particular perspective, and working with that particular platform is shot through with the ownership from top to bottom.
But why couldn't Congress prohibit Americans from associating with certain foreign organizations that have interests that are hostile to the United States. I mean, I thought that's what Holder versus Humanitarian Law Project allowed. So I don't really understand what you mean.
Right, so I'm glad you're bringing that up.
Yes.
So when it comes to this national security, you are right that Congress can prohibit Americans, to use that case as an example, from associating with terrorist organizations or other organizations that pose a clear and present danger to this country. This case, Justice Jackson, is fundamentally different. What the government tells you in its own brief that it is worried about here are the ideas that might be expressed on TikTok. We might undermine U.S. leadership. We might sow doubts about democracy. We might have pro-China views. And so if you look to whether that is legitimate interest, my fundamental submission, and this I think goes to the last colloquy you were having with Mr. Francisco, is that is an impermissible government interest. And you look throughout our history and tradition, and I think the place I would point you most directly would be the opinions of Justice Brandeis and Whitney and Justice Holmes and Abrams.
I guess I don't understand how that's distinguishable from what's happening in Holder. So can you just say a little bit more?
It goes to the nature of the national security threat. So my position is the government just doesn't get to come in and say national security in the case is over, or you don't get to associate. You have to dig underneath what is the national security claim. And what Justice Holmes said in his Abrams dissent, and I know that was a dissent, these are hard issues, but that has been vindicated over time, is that it's not enough to say national security. You have to say, what is the real harm? Is it, is it terrorism? Is it where our battleships are located? Is it war?
Justice Kavanaugh presented a number of potential risks, right, with foreign adversaries using covert manipulation of the data platforms that are being used by youths today that would then make it more likely that people would turn into spies and do terrible things to the United States. This is a hypothetical, but you know what I'm saying?
I get it. So I think if I understood Justice Kavanaugh correctly, he was talking about the data security argument. So let me just pull these apart. You first have an argument, and the government itself separates these two arguments in its brief. The first argument, the one I'm focusing on initially, is the content manipulation argument. And that argument is that our national security is implicated if the content on TikTok is anti-democracy, undermines trust in our leaders. They use various phrases like that in their brief. So my primary submission is that is an impermissible government interest that taints the entire act. Now there's a secondary argument the government makes, and we say you don't even get to that because once you have an impermissible motive like that, the law is unconstitutional. But even if you could get to that, Justice Jackson, I do grant that data security and the way Justice Kavanaugh spelled it out is compelling. That is compelling, but that's not the question. You just don't ask in the air, was Congress worried about data security or could it reasonably be worried about data security? You say, can this act, the act before you, be sustained on data security grounds? And our answer to that has to be no. You don't have to look any further than the divestiture provision itself, which says that the content recommendation algorithm cannot be used in the future. Well, that has nothing to do with data security. So the core feature of the divestiture provision is going at content manipulation, which I said is impermissible. You can't uphold that under data security grounds. And the rest of the act, when you look at the covered companies provision, Justice Jackson, if this were primarily a data security law, what you think you'd find is what kind of data is procured? How is it stored? Is it shared? Those are the things you think you'd find under covered companies, but you don't find that. What you find is, are text images shared? Is content being shared between users? Is it being created and posted in a social media platform? So I don't dispute for 1 second that data security is a very important thing, and Congress in this very law regulated data security in other ways with data brokers. That's perfectly permissible. But the question before you today was narrower. The question is this law before you sustainable on data security grounds? And that answer has to be no.
Congress doesn't care about what's on TikTok. They don't care about the expression. That's shown by the remedy. They're not saying TikTok has to stop. They're saying the Chinese have to stop controlling TikTok. So it's not a direct burden on the expression at all. Congress is fine with the expression. They're not fine with a foreign adversary, as they've determined it is, gathering all this information about the 170 million people who use TikTok.
Well, again, Mr. Chief Justice, if I may, let me separate where you started, which was the content manipulation, and then go to the data security part of it. So,
well, the first part was not. I'm not talking about the content manipulation. I'm talking about the content harvesting.
When you say content harvesting, do you mean people's data?
They've got
or
all the information, whatever whatever algorithms they want, that has access to the personal information, or at least information that is not readily available, about 170 million Americans. And whether they're going to use it in 10 or 15 years, when those people grow up and have different jobs in different places, or whether they're going to use it now. That, at least as I look at the congressional record, is what Congress was concerned about.
Well, I think
and they're not concerned about the fact that it is available. As I said, the remedy is just somebody else has to run TikTok. So they're not concerned about the content. They're concerned about what the foreign adversary is doing.
So if I may, I think to answer your question properly, I think I have to separate two things. One is the content recommendation algorithm. And that's what I was speaking about a moment ago. That has nothing to do with data security. That doesn't itself procure data. That just determines what videos people see on their feed on TikTok. As to that, I think the answer is inescapably that the government and Congress itself was worried about content. The government itself is here saying national security. So like a mix of cat videos or dance videos doesn't affect national security. No matter what happens, the only thing that can affect national security are the substance of those videos. And when the government's pressed in its briefing, it outright tells you that. It says what we're really worried about is sowing doubts about U.S. leaders, et cetera. So let me turn then to data security. Yes, there were various congresspersons, and in the record that we have in the D.C. Circuit, there were conversation about the problem of data security here. As I said, I don't dispute that that is a valid governmental interest. So I think you addressed whether that alone can sustain the act in two steps. First, you would ask, if you have an impermissible motive and a permissible one, can we sustain the act based on the based simply on the permissible motive? And I think for the reasons Mr. Francisco said, and we lay out in our brief, that alone, the answer is no under Hunter against Underwood and other cases. Even if you could get just to the data security question, again, you'd have to ask the question, would this law have been passed by Congress for data security reasons? Because you're being asked to uphold a law based on that single governmental interest. And when you look through the provisions, like the content recommendation algorithm provision, like the covered company provisions, the answer is no. And if you're still in doubt on that, just go back to the under-inclusiveness problem. Would a Congress really worried about these very dramatic risks leave out an e-commerce site like Temu that has 70 million Americans using it, and every bit the connection?
Does Congress have to go all or nothing on that? I mean,
it doesn't have to go all or nothing.
They isolate a particular problem, and they might be getting to what you're talking about next. Who knows? But you're really sitting up there and saying Congress would not pass the divestiture law if data security were the only interest.
So I'm saying it would not have passed this divestiture law if data security were the only interest. It's very curious why you just single out TikTok alone and not other companies with tens of millions of people having their own data taken, in the process of engaging with those websites, and equally, if not more, available to Chinese control. So I'm not trying to say that Congress has to do everything at once. I'm trying to say that once you've concluded that content manipulation, for the reasons I've said, as a matter of our history and tradition, has to be impermissible.
Is there another site like this one that covers half the American population?
I don't think, just by way of sheer numbers, Justice Sotomayor, that the answer has to be no. But 70 million seems like a lot.
170 million is a lot, but put that aside and then go to the next question, which is, how many of these sites have all of the data collection mechanisms that TikTok has? From what I understand from the briefs, not only is it getting your information, it's asking, and most people give it permission, to access your contact list, whether that contact list has permitted them to or not. So they can now have data about all of your contacts and anything you say about them. How many other sites gather information by keystrokes to be able to do voice and finger ID information if they choose? And there's a whole lot of data stuff that was discussed in the brief that I don't think any other website gathers. So wouldn't this be a unique site? If I viewed the evidence that way, how would this be under-inclusive?
Justice Sotomayor, I don't think a lot of the suppositions you're making actually bear out. And as Justice Gorsuch was pointing out, one of the obviously the real challenges in this case is it comes to you without an ordinary trial record compiled and all the rest. So we have only limited amounts of information. But absolutely, these other websites are taking much the same kind of information, if not more. And as to the contact list thing, I think that points out one other aspect of this. That is voluntary decision by an American user to share that information. In the Riley case.
But not informed. And
well,
even if informed.
That could be solved. If you don't think it's informed, that could be solved by a warning or disclosure.
No, that can't be, because for the United States, the threat of using that information is what is at issue. It's not whether the user thinks it's okay. It's whether the U.S. believes that it could put sites at issue. But let me ask you one last question and fundamental question. Assuming that content neutral data collection concerns were is one of Congress's provisions, divest because of this. Why can't we separate that out from how we analyze the algorithm question? And couldn't we sever the two provisions to say divestiture is right, but you can't force them not to discuss algorithm?
Well, I think the reason why you can't do that was Mr. Francisco explained. I thought I'd direct you to a case like Hunter against Underwood and just analogize it to this situation. If what you had is the government saying, we are shutting down TikTok or requiring divestiture for two reasons. One, because we think it helps the Democratic Party too much. And number two, because we're concerned about data. I think that first interest would be a poison pill. That would be an impermissible, or because we think there's too much pro-Catholic content on TikTok. I think there are some interests that are just so constitutionally verboten that I think that just makes the act unconstitutional, and you can't go looking for other interests. You send it back to Congress. Look, if you want to pass a data security law free and clear of this impermissible interest, you go ahead and do it. So, can I say one other thing, Justice Sotomayor, just because I think it is also telling here that even if you didn't buy that poison pill argument and you just asked whether Congress would have passed this law, something else that I think you might notice is even if all this act goes into effect and the law goes through, TikTok gets to keep all the data. So wouldn't a data security law require them to expunge that data or get rid of it or something? I mean, it's a very weird law if you're just looking at it through a data security lens, and maybe Congress could do better.
Mr. Fisher, often we require divestiture for antitrust reasons, for example. And as I take it, your argument here, and we don't think of those as normally implicating the First Amendment interests of users or people who might speak or associate with editors. And the difference here is, as I understand it in your mind, that this law is motivated by a content-based interest. Is that a fair summary?
I think that, and the only thing I would add to it is just the prior step, which it is regulating the speech itself for content-based reasons.
Yeah,
yes.
We don't do that in the antitrust area, but
exactly.
You say this law does. Okay.
Exactly.
And it does on the covert content manipulation side. Do you think that's a compelling interest or not? Forget about the tailoring for a moment.
No, my point is that preventing content manipulation, whether it's covert or not,
is simply not
impermissible if what you mean by content manipulation are the kinds of interests the government is saying, like undermining trust in our leaders, undermining trust in democracy. That's Whitney and Abrams, and like those cases.
I got it.
Yeah.
I got it.
So, Mr. Fisher,
just a couple more. I'm sorry. I'll finish up real quick. And so that would take us to the tailoring question. And there you say disclosure. And alerting Americans that there is covert content manipulation possibility, putting aside the data collection part of it. Yeah. Telling Americans that there is covert content manipulation going on in TikTok, or at least it's possible. And the government says that's just simply not enough. And the D.C. Circuit did too, and I wanted to give you a chance to respond to that.
Right, so I think that's the only aspect of the governmental interest that could be permissible, the covert part. And my answer, as you just said, is disclosure solves that problem. And you have a long-standing law, which we haven't talked about yet today, that gives you that example. Again, under a history and tradition test, you look at not just precedent, but laws and traditions of our country. Look at the Foreign Agent Registration Act. passed in the run-up to World War II, and the concern was Americans would be controlled by foreign agents to speak and advocate certain causes.
We didn't ban them.
You did not ban them. All you did is require, Congress, all Congress did was require disclosure.
Certainly wasn't. I wasn't around for that. On the secret evidence point, I'm concerned about the government's attempt to lodge secret evidence in this case without providing any mechanism for opposing counsel to review it. And I expressed that concern in Zabeta, and I noted that there are mechanisms to read in counsel and that other countries, including our allies, often do that. I just wanted to give you a chance to give me your thoughts on that.
Yes, Justice Gorsuch, we made all those arguments in the D.C. Circuit, so there was a flurry of motion practice about whether or not the government could rely on classified evidence. Those motions were never resolved. What the D.C. Circuit did, I think you probably noticed from the decision, is say we're going to decide this case solely based on the public record. And my understanding is that's how it comes to this court. But if the court were ever...
It's interesting that Congress hasn't acted in this field. I mean, we have in the FISA area, lots of opportunity. They have regulated this area, and it does seem like an area that Congress might want to pay attention to, given the increased appeals to secret evidence that the government has made in recent years. Last question for you. Could the new administration, after January 20th, Mr. Francisco suggested that it might be able to extend the deadline, even though if you were to lose here by January 19th? Is that possible as you read the law?
I'm not sure it is. I'm not sure. Maybe that's a question for the Solicitor General. But
it certainly is. I thought maybe I'd give you a chance, too.
So, as I understand the law, it's 270 days unless extended. And once that time runs, I'm not sure you're talking about an extension anymore.
Okay.
There's ex post facto law that kind of does this stuff.
Thank you.
Can I take you back, Mr. Fisher? Let's say I agree with you that if you're talking about content manipulation, that's an inherently content-based rationale for acting. So if Congress had passed a law that says we hate the content manipulation that TikTok is doing, that's strict scrutiny land, and I don't know that the government can do that, however important and the interest. But that's not what Congress is doing here, and this is the same kinds of questions that I asked Mr. Francisco, because if let's take it as a given that Congress actually can do whatever it wants with respect to a wholly foreign corporation or a foreign government. And so Congress could act with the intent to interfere with the content manipulation that a foreign corporation is doing. And so now we're in this strange world where we're saying they can't act with respect to TikTok. They could act with respect to ByteDance. Why isn't this Congress acting with respect to ByteDance in the sense that all it's doing is saying ByteDance has to divest, and then TikTok can go about its business, use whatever algorithm it wants, use whatever content moderation policies it wants, just like everybody else does, choosing from everything that's available on the open market?
So let me answer that question in two parts, from the perspective of the creator Americans who want to use this platform to speak to other Americans. So the first thing is what the act does, as you said, Justice Kagan, is prevent us from working with an application that is owned by ByteDance that uses this algorithm. Well, that's exactly what we want to do. That's our editor and publisher of choice that we think best disseminates our speech.
Yeah, but what I'm saying to you is if you just assume a world without TikTok, that where it's only ByteDance, and you were trying to say, well, we really want to work with ByteDance, and Congress was saying, we think ByteDance presents national security interests, and they don't have First Amendment rights. They're just a foreign corporation. I think that in that case, the government, tell me if you think this is wrong. It just doesn't matter that you have creators who want to work with ByteDance, because ByteDance is a foreign corporation with no First Amendment rights. Is that what you're contesting?
So that is what I'm contesting. So you said two things, though, so I could be clear. There's two aspects. Do we have a First Amendment right to work with a foreign company or even a foreign country to publish our speech? And then there's a national security part that you put into that, which goes to the justification.
Forget that.
Forget that, yes. Let's do that. So if that is right, Justice Kagan, then American creators have no right to make documentaries with the BBC. They can't work with Al Jazeera if Congress wants to prevent that. Any number of other publications that are state-owned wholly or partially. And even under Lamont, remember, where you're not even creating speech, you're just listening. That was speech from China. that the court said you have a First Amendment right to receive.
So would I be right to say that your position is that because of the users who want to associate and want to partner with this foreign corporation, the foreign corporation ends up having, in your view, the exact same First Amendment rights as your users do? In other words, it's irrelevant that the foreign corporation doesn't have First Amendment rights.
I don't think it's irrelevant, because you could imagine a situation where no American distributor or speaker wants to work with that. But let me put it to you this way. The Communist Manifesto, written by Karl Marx, has no First Amendment standing on its own in America. But if a bookstore wants to sell that publication, I don't think Congress can prevent it from doing so.
Well, sorry. Go ahead.
No, I'm fine.
No.
I'm good.
Okay. So I want to press you a little bit on the distinction, because in Lamont, the prohibition worked directly on the American. Like, you have to specifically request this information that comes. This is working, kind of as Justice Kagan's questions were pressing you, this is working on ByteDance. It's not saying to your creators, you can't post on ByteDance. That's indirectly going to happen if ByteDance chooses itself not to permit TikTok to walk away with the code. So does that matter, that distinction between Lamont and this case?
No, for two reasons. One, under the Sorrell case, you look to not just the law itself, but its practical operation. And the practical operation is prevent us from working with ByteDance. So that's one answer. And you bring up Lamont, and Lamont's actually a very important case, I'm sure you all recognize here. It's important to look not just at the court's opinion, but look at the briefing in that case. The government itself never came in and argued there's no right to receive this information. That's the sort of greater argument. All the government argued was, of course Americans have a right to receive this, but it's just not so much of a burden to require them to raise their hand to get it. So Archibald Cox, when he was the Solicitor General, said to the court quite explicitly in the brief, we're not even going to make this argument because we think it's so contrary to history and tradition. All we're going to argue is the burden isn't enough. Now, what happened is the D.C. Circuit kind of turned that upside down and said, oh, Lamont's just a case about the burden. Well, that's because that's the only argument the government was even willing to make in this court. There was no argument that Americans didn't have the right to hear that speech.
What about, so I think this goes to Justice Gorsuch's questions about antitrust divestiture. Let's say that for antitrust reasons, or let's even say not for that, let's say for suspect First Amendment reasons, Congress tells Jeff Bezos that he has to divest in the Washington Post. You know, he can no longer own the Post. And let's say that neither Bezos nor the Post challenges that. But let's say that you represent clients who really like the Post as it was, who really want to keep receiving the Post, who really want to publish op-eds in the Post. Yeah. Would you have standing? Like, what kind of a claim would you be making there?
I believe so, Justice Barrett. And the court has cited Lamont and other cases in more recent years to say we've recognized a right of American listeners to receive information from others. And remember, even that is that's only a small part of the argument I'm making on behalf of the creators. You know, I don't mean to diminish Mr. Francisco's arguments on behalf of the company and ByteDance, but the core speech in front of you in this case are the videos and other forms of communication that people like my clients are posting by the millions every day on this platform to share with other Americans.
Can you win is it possible for you to win and Mr. Francisco to lose, or you rise or fall together?
No, I think it's possible. I mean, I don't think we should. But
was it possible for you to win and him to lose? And
well,
you want to win?
Let me put it this way. If you were to conclude that something about the corporate ownership structure, and I think there was some conversation about this earlier, impeded Mr. Francisco from being able to assert full-throated First Amendment rights in this case, I would step in and say, well, certainly we can do that and get you to the strict scrutiny. And then the arguments pretty much line up. Then you're in a question of, can the government satisfy strict scrutiny? And I think, Mr. Chief Justice, you asked about, do we have cases for this and that? I think that the idea is, yes, we have cases that say, once you're in strict scrutiny, that regulating the content because you don't think it's going to be pro-American enough or it's going to be too pro foreign interest is just verboten under the First Amendment. That's the history and tradition. And Justice Kavanaugh, when you asked about the broadcast cases, they're grounded not just in scarcity, but they're grounded in scarcity in a particular way. And it has to do with the absolute need Congress has for licensing in a world of scarce resources. And so that's the very small carve-out that even in Turner, the court wouldn't extend to cable television, that exists for broadcast licensing. And if you look on the 200 plus years of our country for any other example of foreign ownership of media being regulated by Congress, let alone being permitted in the case law, you are not going to find it. And I think the reason why is because everybody has understood that if you're not in a world of scarcity where licensing is impossible, you cannot give the government, and in this more extreme example, the president himself, unbridled discretion to choose who is a proper owner of a speech platform in this country. Because it is so hand in hand with viewpoint. As I said earlier, any number of owners of big media enterprises, whether they be Americans or foreign citizens, could be accused of having a particular viewpoint, but speakers who engage in those platforms have choices they can make. And so, on behalf of our creator clients, we find it not at all satisfactory to be told, well, look, just go post somewhere else. It's not enough to tell a writer, well, you can't publish an op-ed in the Wall Street Journal because you can publish it in the New York Times instead. Just like here to say, you can publish it on Instagram or some other platform, not just TikTok. TikTok has a distinct editorial and publicational perspective, and it particularly benefits people like my clients who are not famous people, they're not actors from Hollywood who have a lot of people following them, they're ordinary American citizens whose content that they create on the platform gets privileged by way of the quality of that content. And that's what's so powerful about the platform. So whether you're an ordinary American citizen or, I might add, whether you're a presidential candidate in our last election, if you want to reach new and different audiences, TikTok is the place people go.
This may not make any difference for constitutional purposes, but just out of curiosity, I'd like you to explain what the practical consequences would likely be for your clients if TikTok went dark, as Mr. Francisco put it. There, I assume, is a great demand for what TikTok provides. And if TikTok was no longer there to provide what your clients really want, is there a reason to doubt that some other social media company would not jump in and take advantage of this very lucrative market?
There are two reasons, Justice Alito. One is many of the declarations from my clients actually explain they've tried on other platforms to generate the kind of audience and engagement they've been able to on TikTok, and they've fallen dramatically.
Yeah, I know they haven't so far, and I'm just wondering whether this is like somebody's attachment to an old article of clothing. I mean, I really love this old shirt because I've been wearing this old shirt, but I could go out and buy something exactly like that. But no, I like the old shirt. Is that what we have here, or is there some reason to think that only ByteDance has this, the ByteDance has devised this magical algorithm that all of the geniuses at Meta and all of these other social media companies, they couldn't. No matter, they put their minds to it, they couldn't come up with this magical thing?
I think empirically, other companies have been trying for a few years to catch up with TikTok and replicate it and have been very unsuccessful. And so that ought to tell you something. And so just imagine the algorithm here as a collection of thousands of editors. Imagine the floors of an office building being filled with a collection of editors. You could imagine a situation where that collection of genius that is on a particular floor cannot be replicated by another group of people. And that's kind of what you have here.
All right, I understand that.
Thank you, counsel. Justice Thomas? Anything further, Justice Alito?
Yeah, one other question. I'm intrigued by your Mount Healthy Hunter versus Underwood argument. I mean, maybe you're right, but Mount Healthy arose in an entirely different context where you're trying to get to an employer's motivation. Hunter versus Underwood involved an extreme situation where the court looked at the records of a state constitutional convention and came to the conclusion, apparently, that racism was the only motivation for what was done. But it does seem to me to be potentially quite unworkable and contrary to what we've generally said about legislative intent to apply the Mount Healthy framework to a congressional enactment. Do you recognize or do you acknowledge that that would be very difficult? Because when an act of Congress is passed, there could be more than 250 different motivations for the votes that were cast by the members.
Yeah, I totally understand that. And in Hunter, the court actually engaged with that problem to some degree. And what Hunter said is, to avoid that problem, we're going to look just at two things.
Before we continue, the Supreme Court's hearing on TikTok, President-elect Trump just spoke at his New York sentencing today, where he described the case as a terrible experience. Trump said he was innocent and did nothing wrong. He appeared virtually at the hearing from Florida, along with his lawyer, Todd Blanche.
Justice Juan Merchan said he will grant an unconditional discharge. That means he would place a judgment of guilt on Trump's permanent record without any other legal penalties, such as custody, a fine, or probation. Here's a recap of the sentencing.
Thank you, Your Honor. This has been a very terrible experience. I think it's been a tremendous setback for New York and the New York court system. This was a case that Alvin Bragg did not want to bring. He thought it was, from what I read and from what I hear, inappropriately handled before he got there. A gentleman from a law firm came in and acted as a district attorney, and that gentleman, from what I heard, was a criminal or almost criminal in what he did. It was very inappropriate. It was somebody involved with my political opponent. Part of the records that we're talking about, they're saying, I just noticed where he said I was falsifying business records. Well, the falsification of business records, as they say, it was calling a legal expense in the books where everybody could see them, a legal expense. In other words, that legal fees or legal expense were put down as legal expense by accountants. They weren't put down by me, they were put down by accountants. I didn't call them construction, concrete work. I didn't call them electrical work. I didn't call them any. They called a legal fee or a legal expense, and for this, I got indicted. It's incredible, actually. Now, if you look, my attorney alluded to it, the top legal scholars and legal pundits in this country, the ones that are quoted all the time on television, that are making their views felt, and highly respected people, have said, everyone, virtually everyone that I know of, I haven't seen any to the contrary, not one. And none of these people are not exactly friends of mine, to put it mildly. But they all said this is a case that should have never been brought. It's an injustice of justice. Very respected Jonathan Turley, Andy McCarthy, Judge David Rifkin, a wonderful man who just passed away, by the way, Greg Jarrett, Ellie Honig from CNN, of all places. CNN said that. Paul Ingratian, Alan Dershowitz, they all said this is not a case that should be brought. It's not, think about it, legal expenses are down as legal expenses, and I get indicted for business records. Everybody should be so accurate. It's been a political witch hunt. It was done to damage my reputation so that I'd lose the election, and obviously that didn't work. And the people of our country got to see this firsthand because they watched the case in your courtroom. They got to see this firsthand, and then they voted, and I won and got the largest number of votes by far of any Republican candidate in history, and won, as you know, all 7 swing states, won conclusively all 7 swing states, and won the popular vote by millions and millions of votes. And they've been watching your trial, so they understood it. I wasn't allowed to use the lawyer-client privilege or the reliance on counsel. I had a lawyer that made this deal, and he admitted that. And he was also a totally discredited person. We weren't allowed to use the information from the Southern District that totally discredited him. It wasn't allowed to be put in. And that was terrible, unbelievable. And this is a man who's got no standing. He's been disbarred on other matters, unrelated. And he was allowed to talk as though he were George Washington. But he's not George Washington. He shouldn't have been allowed. The Southern District did a book of approximately 28 pages where I've never seen anything like it. They excoriated him. You wouldn't let it be put into evidence. So he was able to testify as a witness, and I think it's a disgrace to the system. I was under a gag order. I'm the first president in history that was under a gag order where I couldn't talk about aspects of the case that are very important. I guess I'm still under, so probably I won't do it now. I assume I'm still under a gag order. But the fact is that I'm totally innocent. I did nothing wrong. They talked about business records, and the business records were extremely accurately counted. I had nothing to do with them. That was done by an accountant or a bookkeeper who I think gave very credible testimony and was corroborated by everybody that was asked. And with all that's happening in our country today, with a city that's burning to the ground, one of our largest, most important cities burning to the ground, with wars that are uncontrollably going on, with all of the problems of inflation and attacks on countries and all of the horrible things that are going on, I got indicted over calling a legal expense a legal expense. It was called a legal expense. I just want to say I think it's an embarrassment to New York, and New York has a lot of problems, but this is a great embarrassment. I believe that this and other cases that were brought, as you know, the DOJ is very much involved in this case. It's because that's the political opponent they're talking about. The DOJ is very involved. You have a gentleman sitting right there from the DOJ who was from the DOJ's office. He was also involved with the New York State Attorney General's case. And he went from there to here. He went around and did what he had to do. He got them to move on me. But in the meantime, I won the election in a massive landslide. And the people of this country understand what's gone on. This has been a weaponization of government. They call it lawfare. Never happened to any extent like this, but never happened in our country before. And I'd just like to exclaim that I was treated very, very unfairly. And I thank you very much.
Thank you, Mr. Trump.
The Supreme Court is now hearing arguments over the TikTok ban.
Let's tune in.
It's, you name it. What are the new ones? Blue Sky? I mean, none of these are apparent, right? You get what you get, and you think that's puzzling, and it's all a little bit of a black box. So you can't just mean it's a black box, it's covert. They're all black boxes. And if you just mean what's covert is the fact that there's China behind it, I mean, honestly, really, like everybody does know now that there's China behind it. So I just don't get what this covert word does for you.
I think the problem with just saying as a general matter, China has this capability and might at some point be able to exercise it and manipulate the platform is it doesn't put anyone on notice of when that influence operation is actually happening, and therefore it doesn't guard against the national security harm from the operation itself.
Isn't that a pretty paternalistic point of view? I mean, don't we normally assume that the best remedy for problematic speech is counter speech? And TikTok says it could even live with a disclaimer on its website saying this can be covertly manipulated by China. In case anybody were left in doubt after today about that possibility. So you're saying that won't work because?
That won't work because it is such a generic, generalized disclosure that it wouldn't put anyone reasonably on notice about when it's actually happening. And the example I've been thinking about is—
argument is that the average American won't be able to figure out that the cat feed he's getting on TikTok could be manipulated, even though there's a disclosure saying it could be manipulated.
But imagine if you walked into a store and it had a sign that said, 1 of 1 million products in this store causes cancer. That is not going to put you on notice about what product is actually jeopardizing your health. And I think that's roughly equivalent to the type of disclosure they're contemplating here. They brought up the example of the Foreign Agents Registration Act, FARA. There you have to disclose the actual content.
If that's true, then wouldn't that be true for all social media companies, for all content? I mean, every editor, every newspaper in its editorial room makes decisions about what it's going to run and how it's going to say it. And every algorithm has preferences, whether it's domestic or foreign. And nobody really knows exactly when those editorial decisions are being made or how. But they're generally aware, and we think that's enough.
I think, though, that there is a real risk that when a foreign adversary has control of that kind of mechanism and a speech platform in the United States, it could weaponize that platform to harm United States interests. And one of the key ways that the PRC flexes this muscle is to suppress speech.
General, I'm sorry to interrupt you, but we're not arguing about the compelling interest. We're arguing about the tailoring.
Right. And so I guess what I would say, you began by saying the cure for concerning speech is counter speech. Here, I dispute the premise that Congress was specifically concerned about any particular subject or any particular viewpoint. It wanted to close off a capability of a foreign government. But in any event, it's very hard to engage in counter speech when you don't know because someone is secretly manipulating the platform behind the scenes. And in particular, what the PRC has the capability to do is simply silence American voices.
With a newspaper owned by a foreign company and a foreign government, you wouldn't know when it's exercising editorial discretion about this article or that article or how it's doing it. So maybe we just need to shut down the Oxford University Press in America, or you pick it, any other foreign-owned Politico, I was told today, is owned by Germany.
So
that would all be okay on your theory so long as Congress designates that country a foreign adversary?
We are not asking the court to articulate bright line rules to govern all kinds of hypothetical situations.
I am testing your argument.
Yes, and what I want to acknowledge is that sometimes the court has recognized that a speaker-based preference might reflect a content-based preference. And in the context of ownership of a newspaper, for example, in part because a newspaper is a one-way channel of communication and is generally understood to represent to some extent its publisher's views, maybe the court would more readily infer that a regulation targeting that is actually aiming to target content. But I don't think the court could draw the same conclusion here.
I'm not talking about the compelling interest or any of that. I'm talking about the tailoring. And you're saying we have no alternative but to stop this speech altogether. We can't rely on disclosure. But you say that wouldn't apply to Politico or to the Oxford University Press because?
In the circumstance where you have a newspaper that is understood to reflect its publisher's views, then you might think that disclosure would be a more adequate remedy there because it's not just holding itself out as a forum for speech between other people. I think social media platforms do raise distinct interests in this regard because what people think when they're engaging with TikTok is that it's organically feeding them videos based on the recommendation engine. And if actually China is behind the scenes engaging in this kind of covert operation, it does prevent a distinct national security risk. Of course, the other big difference with a newspaper is it's not likely to be collecting sensitive personal information about 170 million plus people and then having the capacity to send that back to a foreign adversary.
General Prelever, can I? Oh, go ahead.
I was just going to say, did I understand you to say a few minutes ago that one problem that ByteDance might be through TikTok trying to get Americans to argue with each other?
That it might be just trying to foment
If they do, I say they're winning.
Or dissent. That might very well be true, Mr. Chief Justice. And I think the point I'm trying to make is that China is a foreign adversary nation that looks for every opportunity it has to weaken the United States and to try to threaten our national security. And if it has control over this key communications channel, it's hard to predict ex ante exactly how it's going to use that as a tool to harm our interests. But we know it's going to try, first and foremost, by seeking to get the data of these American users, which would be of a piece of all of the activity the PRC has already undertaken to breach our laws, hack OPM, for example, and exfiltrate the background files and security clearances of 20 million government employees, the breach of Equifax to get sensitive financial data, Anthem to get sensitive healthcare data. We know that the PRC has a voracious appetite to get its hands on as much information about Americans as possible, and that creates a potent weapon here because the PRC could command that ByteDance comply with any request it gives to obtain that data that's in the hands of the U.S. subsidiary.
Thank you.
General Prelever.
Suppose that TikTok had no connection whatsoever with any foreign government. It was owned instead by an immensely rich multinational corporation, and Congress concluded that this multinational corporation really has it in for the United States and is going to use this extremely popular platform to do everything it can to undermine the United States in all the ways in which you think that TikTok may pursue at the direction of the PRC. Would that be the same case?
I think there would be a first-order question of whether the multinational corporation itself has First Amendment rights.
All right, it's an American corporation.
So if it were an American corporation, I think that, and Congress disagreed with the viewpoints or content the corporation would display, obviously that's a direct regulation of protected speech and it would trigger strict scrutiny. I think that's different in kind from what Congress was worried about here, which was not regulating speech as such, but instead regulating foreign adversary control.
So your argument depends on the fact that what is at bottom here is the People's Republic of China using TikTok. That's what your argument depends on. If this were an American corporation, it'd be an entirely different thing.
Exactly. And the reason we know the statute is different is because all of the same speech that's happening on TikTok could happen post-divestiture. The Act doesn't regulate that at all. So it's not saying you can't have pro-China speech, you can't have anti-American speech. It's not regulating the algorithm. TikTok, if it were able to do so, could use precisely the same algorithm to display the same content by the same users. All the Act is doing is trying to surgically remove the ability of a foreign adversary nation to get our data and to be able to exercise control over the platform.
Oh, sorry.
I'm sorry.
I just wanted to respond to Mr. Fisher's argument about the rights of Americans to receive information, say, from the PRC or anyone else, and that even if ByteDance...
For breaking news and special reports, tune into NTD.
Watch us live at ntd.com/live. Stay with us. We're going to bring you more after this break.
There are real consequences to controlled media. And NTD's founders know them firsthand. Our freedom of thought is the price. This is the lesson that guides us in everything we do.
So there's the tear gas there.
We know the value of a free society. And we take seriously the responsibility to preserve it. We are NTD.
Welcome to NTD News Today. Here are today's top stories. President-elect Trump was sentenced to an unconditional discharge in his New York business records case. NTD's legal correspondent Arlene Richards joins us here in the studio.
At least 10 people killed and over 150,000 evacuated as the devastating fires continue to burn through LA County. How weather conditions are affecting firefighting efforts.
The Supreme Court considers whether to allow a law banning TikTok to go ahead. We have the latest.
Fears that China could weaponize biotech are driving efforts of a group of lawmakers targeting China's military. More on what they want.
President Biden will deliver a farewell foreign policy address on Monday, a look at some possible topics as Trump prepares to return.
How will December's job gains and Trump's potential policies affect the U.S. labor market and Fed rate cuts in 2025? We have analysis.
This is NTD News Today, live from our global headquarters in New York City.
Good afternoon. Today is Friday, January 10th. I'm Don Ma. President-elect Trump appeared remotely from Florida today to hear Judge Juan Merchan make a final judgment on his conviction for falsifying business records. We now turn to our legal correspondent, Arlene Richards. Arlene, good to have you here.
Thank you.
Arlene, Judge Merchan issued something called an unconditional discharge. Can you explain what that is?
Well, under New York law, a judge can decide not to impose a sentence if he feels that it's not within the public interest or that sending the defendant to jail or putting him under supervised probation would not serve justice. So here a judge has a large amount of discretion to make decisions about sentences, but he does have to consider many factors, such as the criminal history of the defendant, if there is one, and in this case, of course, that the defendant was elected the President of the United States.
So this is not your ordinary criminal case, and the judge hinted in his order last week that he was not going to sentence Trump or probation to prison or anything else. So what's the purpose of having a sentencing hearing today?
Yeah, he did say in his order that he wasn't going to, sentence him and that it was going to be this unconditional discharge. He also said that this was an instance where, he didn't feel that the arguments Trump made about presidential immunity would held up. So he maintained the conviction in this case. So usually what would happen is that this is a final judgment. Today, what happened today was a sentencing hearing to make a final judgment. And you have to have a final judgment in order for the defendant to be able to appeal to a higher court. So, we had this proceeding today. They put it on the record, that he was not going to go to jail and that he was not going to be put on probation. But at the same time, he has to have this final judgment so that he can move forward with his appeal.
The prosecution today agreed that the unconditional discharge was the best decision. But previously, they wanted the judge to sentence Trump after he'd finished his 4-year term. What changed their mind?
Well, they were happy to have this I'm sorry, I forgot how to say it. The unconditional discharge. They were happy to have this. I mean, initially they had said, let's extend this until after his 4-year term and hold this, in abeyance here and then sentence him because they wanted to maintain this conviction. So now, with this decision, they can maintain the conviction. And they also said here today that we can respect the jury's verdict. So this is what they really wanted. They wanted to make sure that he goes into the White House as a convicted felon, which he will. But of course, Trump and his attorney today said they're going to appeal.
All right, Arlene, thank you very much for that.
Thank you.
Up next, firefighters are reporting some progress in Los Angeles County, but the strong winds that fanned the flames are expected to pick up again today, worsening conditions. As of early this morning, five fires were still burning. Here's Los Angeles Mayor Karen Bass on the latest firefighting efforts and support from the local government. The federal
LAFD battled all night on the Palisades fire, the Hearst fire, the Kenneth fire, and airdrop efforts, thank goodness, continue. LAFD also responded to and extinguished fires in Pacoima, Hollywood, Studio City, and more. I do want to let everyone know that Griffith Park, including Runyon Canyon, will be closed through Sunday. Yesterday, President Biden pledged his full support for response efforts, including FEMA reimbursement 100% of our disaster response costs. FEMA also launched resources and support for Angelenos impacted by these fires. Visit disasterassistance.gov to apply.
The Palisades fire between Santa Monica and Malibu and the Eaton fire already rank among the 5 most destructive in Los Angeles history. The Kenneth fire broke out yesterday near Calabasas, one of the wealthiest cities in the U.S. It's home to numerous celebrities and gated communities. LA firefighters said yesterday they stopped the progress of that blaze.
The multiple fires have so far killed 10 people and destroyed nearly 10,000 structures. Some 150,000 residents are still under evacuation orders. Firefighters are hoping for a break today from the gusty winds that fueled the blazes, but weather conditions may keep complicating firefighting efforts next week. Meanwhile, millions of residents received evacuation alerts that were issued in error in the city of Beverly Hills, but they were then quickly told to ignore these alerts. Los Angeles County apologized today for the issue and urged residents to remain vigilant. A number of residents of the Pacific Palisades and Altlandia have returned to find their homes burned to the ground. Multiple wildfires have left some communities in Los Angeles County unrecognizable. NTD's Andrew Thomas has more on their experiences.
The Foster family returned to their home in the Pacific Palisades on Thursday. They surveyed what was left amid the ash and rubble. Kelly Foster described the fear and uncertainty.
We go to Santa Monica, the winds are high. I'm starting to get really terrified there. Also thinking, is this all going to spread? We're watching these plumes of smoke in the sky, and we were glued to the TV. We were glued to the TV for hours.
11-year-old Sam Foster didn't expect the wildfire to be so destructive.
It's definitely weird. I mean, I didn't really think it would be this bad. Like, I was at school, I saw the fire in person, and it didn't look that bad, so I thought it was like a free day off. I thought it was gonna be easy to contain. And then when I came home, after like an hour, it started getting worse and worse. I got scared and nervous.
16-year-old Ada Foster was home alone when the evacuation order was issued. She was shocked by the devastation the fire left in its wake.
It's crazy, it's shocking. I'm kind of at a loss for words. It's hard to even speak about it. I mean, driving through, you've seen all the videos on social media. It's hard for me to even go on my phone because I'm just like, I don't want to see anything. It just makes me so sad.
The Eaton fire burned from the foothills into the urban community of Altadena on Wednesday. 61-year-old resident Alita Johnson recalls fleeing her home.
That night when we left, it was so frightening. You could barely see I could barely see my hand in front of me because the visibility was so bad.
Johnson grew up playing in this neighborhood. Now charred debris and ash are all that remain.
But nothing prepares you for this amount of destruction. I mean, there's no manual, there's no book.
Back in the Pacific Palisades, 65-year-old resident John Carr defied evacuation orders. He felt obligated to stay behind and try to protect his home.
The house was built by my mother and father in 1960, and I lived here my whole life, so there's a lot of memories here. And I think I owed it to them as well to try my best to save it.
Carr's house is one of just a handful of properties that's still standing.
You know, but some things in life are worth fighting for, you know? I mean, if I were to lose this house, it would be very difficult to afford to be able to build a new house, to pay the enormous property taxes they have here. What would I do?
Andrew Thomas, NTD News.
Continuing with the fires in Los Angeles, the Pacific Palisades area is one of the most expensive neighborhoods in the U.S. It's home to Hollywood A-listers and multi-million-dollar mansions. Ahead of this week's disaster, its insurance costs were among the most affordable in the country. Here's a look at how the fires may impact homeowners' insurance in that region.
They're the most destructive wildfires ever seen in Los Angeles, and that has insurance companies braced for a big hit. JP Morgan on Thursday estimated losses to the sector could hit $20 billion. That's double its estimate from just a day before. Ratings agency Moody's also puts the probable losses in the billions of dollars. It says the number is inflated by the way the fires hit neighborhoods like Pacific Palisades and Malibu, which are full of high-value homes. But experts say many properties may not be covered by fire insurance. Homeowners have found it increasingly hard to buy cover in disaster-prone states, with many insurers pulling out of the market. In California, regulators had until recently capped prices for insurance. That limited annual increases, but led many providers to flee the state, saying they couldn't make a profit there. Now the wildfire disaster is set to make the problem worse, with premiums likely to soar and more companies refusing to provide cover at all. One expert said it would be hard to offer affordable policies in hard-hit areas like Pacific Palisades, which would remain at high risk of future fires. History shows what can happen. In hurricane-prone areas like Louisiana and Florida, insurance premiums more than doubled following big storms in recent years. On Thursday, Germany's Munich Re, the world's largest reinsurer, said insurers saw losses from natural disasters hit $140 billion in 2024, one of the highest numbers on record.
Images from space reveal the spread of the most devastating wildfire in the history of Los Angeles.
Russian cosmonaut Alexander Gorbanov captured the images from the International Space Station. They showed the fire burning between Santa Monica and Malibu. Pictures captured by aboard the International Space Station show the fire burning between Santa Monica and Malibu.
Coming up, how will December's job gains and Trump's potential policies affect the U.S. labor market and Fed rate cuts in 2025? We have analysis.
President Biden will deliver a farewell foreign policy address on Monday. A look at some possible topics as Trump prepares for his return to the White House after the break.
Kids love it. Parents trust it. Obviously.
Explore GJW Plus Kids Series and Gone Campus courses led by expert educators.
This is spectacular.
Children will learn values like respect, responsibility, and knowledge in language, science, and more.
Wow.
All while having fun.
Perfect.
Subscribe today at GJW Plus Kids, where learning meets fun.
Supermodel Cindy Crawford doesn't just walk the red carpet, she rocks it. At 58, she steals the show and wows the press. Hollywood Life exclaims, Cindy Crawford has never lost her stunning glow. While Page 6 raves, she's still as gorgeous as ever. What is Cindy's secret? It's meaningful beauty. And now with new advanced formulas, it's better than ever. Watch as the appearance of lines and wrinkles are diminished in just weeks. It's no wonder everyone's talking about meaningful beauty.
My makeup artist said, your skin has been looking great lately. What products are you using? And I said, I'm using Meaningful Beauty. And she said, really? I've tried Meaningful Beauty before. I love those products. And then the other lady down in the trailer said, I use Meaningful Beauty. I love it.
Our new and improved formulas deliver age-defying ingredients even deeper into the skin where wrinkles begin. And this brand new offer is Cindy's most exciting ever. Because when you order, you'll get Cindy's exclusive Super Brightening Duo, a $120 value absolutely free. First, you'll get 60 of our Revive and Brighten eye masks, the celebrity secret that visibly smooths, awakens, and restores the area around your eyes. Next, discover the power of our Vitamin C Biphase Brightening Oil for an immediate boost of glamour and glow.
I'm not ashamed to say I am 53 years old. Thank you, Cindy.
The total effect of this free gift package? A red carpet ready complexion. Get all this, a $300 value for just $49.95. But you must act quickly. Results guaranteed or your money back.
So make the call or go online now and put yourself on the path to the most beautiful skin of your life. Trust me, it's worth it.
This special offer is not available anywhere else, so don't delay. Scan the code, go to meaningfulbeauty.com, or call the number on your screen now.
We come from a long line of farmers, and there's a sense of pride, but there's also a significant amount of pressure.
Farmers have to take care of their physical and their mental health, because what's a farm without a farmer?
Watching the sun come up, that's my time. I can have a cup of coffee, and every day is a new opportunity.
That's cool. Your hand's gotten so
Yay!
Don't forget to check in on yourself. Love, your mind.
Welcome back. The U.S. economy ended 2024 with unemployment falling to pre-pandemic norms. According to the Bureau of Labor Statistics, the nation's jobless rate was 4.1%, and that was helped by the 256,000 positions added in December. The agency says roughly 2.2 million jobs were gained in all of 2024, which is similar to the yearly totals from 2017 through 2019. Analysts say the sturdy labor market helped boost consumer spending, which also overall helped the economy. And joining us now to discuss is Mark Hamrick, Bankrate Senior Economic Analyst. Good to see you, Mark. It's been a minute. How's it going?
Doing well, Don. It's a new year, too. Great to be with you.
Yes, sure is. So what do you think? What's the biggest takeaways for you, at least in the last report of 2024?
First of all, it is a reassuring report in the sense that the job market came in better than expected in the month of December. We can think back to the fall when we suffered through a growth scare, when we had some lackluster hiring numbers. Some of that seems to have been associated with some of the climate events, the bad weather, the storms, the flooding that we were suffering, particularly in the southeastern United States. And so to have the unemployment rate going back down to 4.1%, having greater than expected number of jobs added on the month, that suggests that the economy was continuing solid momentum as we close the books on 2024.
So do you think the higher than expected job gains, is that bad news for potential cuts to borrowing costs?
This is where it gets complicated, right, Don, as you know well, because there can sometimes be this apparent disconnect between the interests of, to use the phraseology, Wall Street versus Main Street. And we see financial markets reacting negatively today with yields rising, stock prices lower. Why is that? Well, there is concern that with the incoming Trump administration, we could be reigniting the flames of inflation with some of their plans for the economy. And the Federal Reserve has signaled that it does not plan to cut interest rates as aggressively as was thought just about 3 months ago. As an indication of that, we have a Federal Reserve policy announcement due on the 29th of this month. And investors are saying there's basically more than a 90% chance that the Fed will not cut rates at that meeting. Of course, they are data dependent. They need to see how the economy presents itself in the coming months. And so we don't have a high degree of confidence about what interest rate policy will be in the coming year, but that's the bet right now. But I would say ultimately, in terms of what you mentioned in the lead-in, it's good news to have the job market holding up. It helps consumer spending. It means that we have relatively few people losing their jobs. We had jobless claims figures this week that showed in terms of new applications for unemployment benefits, well, they were at the lowest level in 11 months. So that proxy for fresh job loss also signaling essentially a green light for the U.S. economy, at least for now.
What do you think the labor market's going to look like in 2024 with all that being said? In 2025, actually.
We just published, absolutely, Don. We just published our report on a quarterly economic survey that we do at Bankrate. And the economists broadly see that hiring may slow in the coming year, but not so much as to cause a great concern. And they do look, collectively speaking, we put all the forecasts together, for the unemployment rate to rise to 4.4%. Now, over the past decade, Don, the average for the monthly unemployment rate has been in the high 4% range. So that suggests that we would still be below that if the forecasts are borne out in fact. But again, we have, the complicated global economy where many of our international trading partners are not experiencing the same solid performance that the U.S. economy is. That holds back certain sectors of the U.S. economy, including manufacturing, and the many unknowns about how the Trump administration goes about implementing things like tariffs and deportations. Those are huge wild cards.
So last year there was a period where the unemployment rate was on the rise, and some were worried that it will continue to rising. But as we've seen this time around, the unemployment rate actually fell to 4.1%. What do you see there?
I think it's obviously welcome news that the U.S. economy has been more resilient and robust than thought. And that's one of the reasons why the Fed doesn't feel like it needs to essentially put more gas in the tank by cutting interest rates anytime soon. It does not feel a sense of urgency in the need to reduce restriction, but that's still the outlook, at least in part, with maybe a couple or three rate cuts in 2025. But I think it's reassuring that the economy dodged an often predicted recession. In that same quarterly survey of economists that I just mentioned about that people can read at bankrate.com, the economists put the risk of a recession over the next year at 1 in 4, or about 25%. And that's the lowest level since we began asking that question in 2022, when that was a grave concern. And over the course of the coming several years since then, they put the risk of a recession as high as 1 in 2, or about 50-50. So we've kind of put that risk back in the bottle. But like so many things, the ability to predict a recession appearing in the not too distant future, we don't have a great track record with that.
Okay, and just going off of your point just now, so economies around the world are seeing slower growth, right? So do you see perhaps the U.S. economy being brought down, being influenced by the conditions beyond our borders? How much of an impact will that be?
Well, we're obviously very dependent on the performance of our major trading partners and the many interconnected economies around the world. The experiences during the COVID pandemic showed us that the interconnectedness not only of economies, financial markets, but also supply chains. And so if growth is underperforming, that has impacts in the U.S. The good news has been that many of our sectors have continued to fare well. But as one indication, we saw essentially no jobs creation in manufacturing in this report. And over the last year plus, one of the major snapshots of manufacturing activity from the Institute for Supply Management has been in contraction most often. And so I do think that reflects the conditions around the world. And that obviously is something we'll just have to continue to monitor.
Okay, just real quick. What's the priority right now for the central bank, the U.S. central bank, in terms of its dual mandate?
I think they do want to see inflation come down. So rates are still restrictive, and they're not going to take that restriction away until they get more confidence about the way inflation's shaping up, hopefully at a lower level.
All right, Mark, great to speak with you today. Thank you very much.
Thank you, Don. Take good care.
Next, Constellation Energy said today it plans to buy privately held Calpine Corporation. It's a geothermal and natural gas energy company. The cash and stock deal is valued at $26.6 billion. Electricity demand is expected to rise to record highs this year. That's according to the U.S. Energy Information Administration. Constellation said together the companies will have nearly 60 gigawatts of capacity from zero and low emission sources. That includes nuclear, natural gas, and geothermal energy. Unlike regulated utilities, Calpine is an independent power producer that can sell power at market prices. The acquisition could add $2 billion to Constellation's free cash flow annually. The deal is expected to close in the second half of 2025.
President Biden plans to deliver a farewell foreign policy address Monday at the State Department.
Some possible topics include his administration's efforts to expand NATO, secure military aid for Ukraine, and broker a historic pact between Japan and South Korea.
Biden also picked the State Department for his first major foreign policy speech at the start of his presidency nearly 4 years ago. In his 2021 address, Biden signaled the U.S. was reclaiming its role as a global leader. This after Trump's America First agenda.
Now, the one-term Democrat bids farewell, defending his vision as Trump prepares to return with plans to reshape U.S. foreign policy.
Vice President-elect J.D. Vance has officially resigned from his Senate seat. It will be effective this morning. The first-term senator had to give up his seat before he and President-elect Trump are sworn into office on January 20th. In a letter to Ohio Governor Mike DeWine, Vance wrote, "It has been a tremendous honor and privilege to serve the people of Ohio. It's now up to DeWine to appoint a replacement who would serve in the Senate until 2026 in a special election." The Ohio governor says he'll probably have an announcement next week.
Rudy Giuliani faces a contempt of court hearing today for the second time in a week. This case in D.C. District Court stems from Giuliani allegedly continuing to make false insinuations about two Georgia election workers. That's after they won a $150 million defamation verdict against him. On Monday, a federal judge held Giuliani in contempt for failing to turn over information to election workers Ruby Freeman and Shay Moss as they tried to collect their damages. In 2023, a jury in Washington, D.C. decided Giuliani's statements about Moss and Freeman caused them harm and that he should pay damages.
Outgoing Canadian Prime Minister Justin Trudeau said he had good and productive meetings with business leaders in Washington today. Trudeau downplayed any talk about Canada one day merging with the U.S.
When it comes to Canada being looked at as the 51st state, let me just state it again, that's never going to happen. We have become incredibly successful as countries, as economies, as a continent, because we do things so well together.
Trudeau said it's important to avoid unnecessary tariffs on goods and products from Canada and promised to stand up for what he called the interests of workers and consumers on both sides of the border. President-elect Trump has threatened to put a 25% tariff on Canadian goods. Canadian officials have threatened to put tariffs on American imports in retaliation. Coming up, fears that China could weaponize biotech are behind the efforts of a bipartisan group of lawmakers targeting China's military. More on what they want.
Britain's Treasury chief is seeking to build up economic ties with China, this despite recently exposed security threats traced back to alleged Chinese spies.
Several European politicians are calling on the European Union to act against Elon Musk. They're accusing Musk of undermining democracy after he showed support for Germany's Nationalist Party ahead of the country's elections. More on that after the break.
almost lost. Now, the world awaits the divine culture's return.
بیست و سه سال 16 سال عمري ما هفت
اما داعش کردیان برانبر خشک و دایکانی ازدی ما کاری که دور لهمو چمک دموکراسی و موافقانی مرو و انسانیت او بارودو خی که است های به تایبت لعراق و سوریه بشه که دگرت و با حالانه که اداره اوباما کرد
وریم بو او هفت روز بو و داعش از کرد
تامبوم كرا قوتينيز قريا بما متشكر بهر في ذا نبو باوان رحم نبو
قدامنا سؤالان من خادران نزل باوان نفستم بس نا ما نقو بس ناش بجوش باش.
They would literally be auctioned in front of soldiers, and then the soldiers begin to bid.
زارود وان همو جيبر تي حملي زارود الدم واسسي وان همو جيبر
وحشیگریه که توا عیاره ظلمی که یک جار زور گوره لما افرطانه کرده و تعدایی که زور زوریان لیده کرده اما نه روزانه دست فروشی ده
اليوم التوزيع كلنا نصيب.
Imagine being a child, you know, having a child mentality, and these evil people come and wheel you away from the only safety you've ever known.
Come to Mathis Home and save during our annual clearance event. We have the state's largest selection of sofas with huge discounts on all the latest styles. Get this luxurious sofa covered in a soft, durable leather. It's made to sell for much more, but we have it clearance priced at just $9.98. They're in stock now, so you get fast delivery absolutely free. For the best value, come to the annual clearance event at your furniture superstore, Mathis Home.
Welcome back. A bipartisan group of lawmakers is urging the Biden administration to restrict U.S. biotechnology exports to China's military.
They say Beijing could weaponize biotech to develop toxic pathogens.
They raised concerns about risks to national security, health care, and medical data in a letter to Commerce Secretary Gina Raimondo. The move reflects growing alarm over China's expanding role in biotechnology.
In August, lawmakers called on the FDA to increase scrutiny of U.S. clinical trials in China, citing intellectual property theft and reports of forced Uyghur participation. They say U.S. firms have worked with Chinese military-run hospitals, including in Xinjiang. Human rights abuses against Uyghurs have been documented in the region. A case of suspected espionage for China in Germany. Prosecutors charged 3 German nationals for working with the Chinese Secret Service. They're alleged to have stolen maritime technology with potential military uses. The 3 suspects are a married couple and another man. They allegedly used a company owned by the couple to get in touch with companies and scientific institutions. Prosecutors say the goal was to gain knowledge that could be useful for the expansion of China's maritime power. The 3 allegedly collected information on boat engines, sonar systems, aircraft protection systems, and more. They then allegedly passed this information on to a contact person from a Chinese spy agency. The 3 Germans are now facing espionage charges.
Tensions are escalating between Elon Musk and EU officials. The owner of the X platform has been accused of undermining democracy.
This follows Musk showing support for Germany's Nationalist Party 1 month ahead of elections in the country. Now calls for the EU to act against Musk are growing across Europe's political class. NTD's international correspondent David Vance has the story.
Several European officials have accused Elon Musk this week of enabling interference in European public discourse. On Wednesday, Foreign Minister Jean-Noël Barrot urged the EU to act decisively against Musk. He warned that if the EU fails to do so, France might invoke its own law to ban Musk's platform in the country. This also follows French President Emmanuel Macron's accusation that the CEO of X is supporting a new international reactionary movement. Spanish Prime Minister Pedro Sanchez on Wednesday also accused Musk of undermining democracy without directly naming him. Warnings stem from Musk's recent criticism of the UK government and his open support for Germany's nationalist AfD party on X. The US billionaire plans to live-stream a conversation with Alice Weidel, the AfD leader, ahead of Germany's February elections. Critics argue this boosts the party's visibility and violates EU Digital Services Act rules on transparency and fairness. According to legal expert Guillaume Zambrano, this marks an escalation of tensions between the EU and the X platform's owner.
There were tensions with Elon Musk and the EU Commission, but it was just at the stage of threats. Now, I think this is a case of EU authorities doing a political blackmail on Musk. We can say this is a weaponization of the legal framework. In other words, both French law and the European Digital Services Act, the law for confidence in the digital economy, and European regulations.
Former European Commissioner Thierry Breton called out Musk's support of German nationalist party AfD. He said in cases where the party wins due to what he called Musk interference, the EU could go as far as cancelling the outcome of the German elections, similar to its recent action in Romania on December 9th. EU Commission President Ursula von der Leyen has not reacted to the concerns raised, and the EU Commission affirmed Musk's right to express his views, but said it would monitor his debate with the AfD leader. For some political commentators, the issue is testing the EU's willingness to confront Musk head-on and risk antagonizing the incoming Trump administration. David Vives, NTD News, Paris.
Thank you, David. And next up, Britain is seeking closer trade ties with China. The UK's top 3 finance chiefs are in the Asian nation alongside senior bank heads. This despite recently exposed security threats of alleged Chinese spies and amid economic turmoil in the UK. NTD's international correspondent Malcolm Hudson has the story.
British Chancellor Rachel Reeves is in China seeking to boost trade relations. It's part of the Labour government's broader aim to reset ties between the two nations. She will be visiting Beijing and Shanghai. Reeves's trip is expected to restart the China-UK economic and financial dialogue. It's an annual bilateral talk that has been suspended since 2019 due to the COVID-19 pandemic, as well as by deteriorating relations between the UK and China in recent years. The trip comes amid market turmoil in the UK. Government borrowing costs have gone up while the pound has dropped in value. The British Treasury said the delegation to China includes Bank of England Governor Andrew Bailey and the UK Financial Conduct Authority Chief Executive. Representatives from some of Britain's biggest financial service firms will also join the trip. Officials did not provide details, but media reports have said senior executives from HSBC Holdings and Standard Chartered were included. Reeves's visit comes after Foreign Secretary David Lammy travelled to China in October, and Prime Minister Keir Starmer met with Chinese leader Xi Jinping in Brazil in November. Officials said Starmer wants a pragmatic approach to working with Beijing on global security and climate change. However, some in the opposition Conservative Party have said trade should not come at the expense of national security and human rights concerns. British political leaders and intelligence chiefs have warned repeatedly of the security threats that China poses. Calls grew louder last month when it emerged an alleged Chinese spy had cultivated close ties with Prince Andrew. According to officials, the alleged spy carried out covert and deceptive activity for the Chinese Communist Party. Malcolm Hudson, NTD News, London.
The U.S. today announced an increased $25 million reward for the arrest of Venezuelan leader Nicolas Maduro.
It was the same day he was sworn in for a third term, despite credible evidence that his opponent won the most recent election.
The inauguration today follows protests in the South American country and abroad against Maduro's increasingly repressive rule.
On Thursday, the political opposition's most prominent leader reported she was briefly detained by state security forces. The government swiftly denied the accusation, but the claim again drew global attention to Venezuela's protracted political crisis.
Also today, Washington issued new Venezuela-related sanctions. According to a notice on the Treasury Department's website, the sanctions include measures targeting the state oil company chief Hector. And the Biden administration today imposed new sanctions targeting Russian oil and gas revenue. A senior official told reporters that the measures are the most significant sanctions yet against the Russian energy sector, which he said is the largest source of revenue for the Kremlin's war machine.
The official said Russia would lose billions of dollars a month if the sanctions were fully enforced. The move in a bid to give Kyiv and the incoming Trump administration leverage to reach a peace deal in Ukraine. President-elect Trump possibly meeting with the presidents of both Russia and Ukraine, representatives from both nations, and Trump himself recently talked about the separate meetings being set up. Trump says that Russian President Vladimir Putin wants to meet him and that the meeting is being set up. The president-elect cited the need to end the war in Ukraine as the reason for possibly meeting Putin. The Kremlin says progress on a possible meeting is being made. A spokesperson for Moscow added that Russia welcomes Trump's willingness to solve problems through dialogue. And Ukraine's foreign ministry today said that it's waiting for high-level contact with the incoming Trump administration. This includes a meeting between Trump and President Vladimir Zelenskyy. An envoy for the U.S. president-elect was scheduled to travel to Ukraine before the inauguration. Ukraine's foreign ministry says the trip has been postponed until after Trump takes office due to legal reasons.
Japan has approved new sanctions against Russia over its invasion of Ukraine. The measures include freezing assets tied to dozens of individuals and groups. Exports to organizations in Russia and several other countries that have allegedly helped it evade sanctions are also banned. The new sanctions follow Japan's previous rounds, strengthening pressure on Russia. The latest measures add 11 individuals, 21 organizations, and 3 banks to Japan's asset freeze list. Japanese Foreign Minister Takeshi Iwaya will visit the South Korean nation on Monday to strengthen security ties. He will meet with South Korean officials to discuss coordination on North Korea and broader regional concerns. Iwaya's visit is the first by a Japanese foreign minister in 7 years. It comes amid growing tensions with China. And the Supreme Court today hearing arguments on TikTok's impending ban. President-elect Trump and TikTok itself have asked the nation's highest court to prevent the law from taking effect at this time. We're joined now by Mark Miller, senior attorney with the Pacific Legal Foundation. Good to have you with us today, Mark. Who has First Amendment rights here? Because TikTok says that it does, ByteDance in the U.S. does, and that the creators on the platform do. What's your assessment?
It's great to be with you, Steph. And indeed, the oral argument is still going on, or at least it was as of a few minutes ago. And it's been a very complex oral argument. You have one of the best lawyers in the country, former Solicitor General for President Trump in his first term, Noel Francisco, arguing on behalf of TikTok and effectively ByteDance, the owner of TikTok. Then you have another lawyer, Attorney Fisher, arguing for a couple of users of TikTok who said they have free speech rights. And then finally, you have Liz Prelagar, the outgoing Solicitor General or top appeals lawyer for President Biden. And so you have some heavyweights all arguing about free speech versus national security. And it's hard to predict where the justices will come out. It was a hot bench, we call it, where each justice was asking a lot of pointed questions. And I really would have a hard time telling you whether national security will beat free speech in this case.
The justices noted that they're also examining the underlying functions of the First Amendment as they apply here, one of which is, of course, to foster a democratic society. What could be the effect of this ban on democracy in your assessment?
Well, there's 2 issues they're getting at in terms of, as you said, the way our democracy or our republic works. And the 2 issues that Congress was supposedly getting at were, one, ByteDance and manipulating the algorithm that spits out the little videos, the cat videos and the rest that everybody sees that uses TikTok. And then secondly, perhaps a little more concerningly, the way TikTok collects data on all its users. And Justice Kavanaugh said there's a concern here that the government would have that this data could be used to blackmail future leaders of America. If they're a teenager and there's data collected that could be used against them, when they become FBI agents or CIA or perhaps an elected office, China could blackmail them with that information. So if you look at that second issue about data collection, that seems like a very significant national security problem. If you look at the way the content gets manipulated, that does seem more like a free speech problem, and that's what the justices are wrestling with.
And TikTok had said that this ban could have broader impacts. It said that it could even pave the way for the government to force other platforms like X, it said, to divest if the government doesn't like them. But considering the underlying national security concerns, as you mentioned, Brett Kavanaugh brought up, that are driving this ban, how strong is this argument?
Yeah, the lawyer actually named Mr. Fisher, who represented the users, did a great job of suggesting that this idea that ByteDance could be driving the manipulation of content, that if the government were to start picking and choosing whose content is allowed to be shared, why couldn't they go after Twitter? And he didn't say Elon Musk by name, but that's who he was getting at, or X. He also said, what if the government were to say, Catholic content could be shared because for some reason, by implication, the Vatican had become dangerous to the United States. I know that sounds silly, but his point was that once the government starts saying who can pick what gets heard, that really does seem to pull the rug out from what we call our free country here. But at the same time, Justice Kavanaugh did an excellent job of articulating the national security concern. And so what the justices then wrestled with, Steph, was, well, if there's one legitimate reason for the law and one illegitimate reason, does that mean the law can stand? Can they just allow part of it to stand? The bottom line is right now, ByteDance has to be divested of TikTok, or TikTok gets shut down on January 19th, just a little over a week from now.
It is coming up soon. Now, drilling into the data aspect, TikTok says that its data is kept in the U.S., so it's not allowed to be shared by law. How strong are the laws on this, and what are the weaknesses in this case, if any?
Well, Steph, that Noel Francisco, the lawyer for TikTok, made exactly that point. But what he was arguing is that Congress could write a law that would not violate TikTok's free speech rights by demanding that Oracle, that holds all the data on data banks, in the cloud, if you will, in Virginia, that Congress could pass a law that says to Oracle, you can't share any of that data. But that Congress didn't do that. Instead, and he says that would be neutral. But instead, what Congress did was pass a law that just basically goes after TikTok. And he says that was improper. And so at the same time, the justices don't normally want to second guess Congress in that way when Congress says it's dealing with national security. The justices for time immemorial have said that national security, national defense is no place for the courts to get involved with. They have to trust Congress and the president. And so I would say Solicitor General Francisco, former Solicitor General, he kind of had a rough time of it with the justices when he was making that argument, because they said, well, you're just disagreeing with the way Congress decided to protect national security. I would say right now, the justices, without having heard the full argument, it's still ongoing. I think the justices are leaning to saying the law is constitutional and saying ByteDance does have to divest from TikTok. But at the same time, it's a close call. Why did they rush the oral argument if they agreed with the lower court decision? The lower court decision said the law was constitutional. ByteDance had to divest from TikTok. So why would the Supreme Court rush it if they just agreed with the result that's already standing? That's the $64,000 question.
That is such a good point. And what you just articulated there does seem to point to Congress's inherent distrust of the TikTok's connection with China, because TikTok had also, one of the lawyers there had argued that they could just be required to disclose their relationship with China instead of having a full-out ban. So in terms of the so if you'd speak to that.
Yeah, I'll pick up on that. Justice Gorsuch was right where you are, Steph. He was saying, isn't this just a question of disclosure, that it's up to the user if they want to expose their data to ByteDance and to China, to our foreign adversaries? You would hope the user wouldn't, but as we know, users agree to a lot of things that they don't realize, whether it's our contracts when we use the internet, or with those, that we just check a box electronically, or when we get in our car and there's all sorts of agreements with the car seller. We agree to this, that, and the other all the time. And so to say that disclosure is enough to protect us from China, to the extent that China is going to misuse this data, seems a little naive when the government is saying this is a real risk. And as I said, Justice Kavanaugh, not surprisingly, since he worked in the Bush administration, Bush II, he was the one most attuned to the idea that people could be blackmailed with data, that shows they did something perhaps they would not be proud of when they were teenagers or young adults that could be used against them later. Kavanaugh typically does a good job of advocating the executive branch's perspective on these things. And effectively, I would say he is a vote for sure. Well, I don't want to say for sure, but he seemed like a lean vote for the government in the case to say the law is constitutional.
Watching it closely. Thank you so much, Mark Miller from the Pacific Legal Foundation. Great to have you with us.
Thank you, Steph.
Is deep-sea fish oil really healthy? Due to pollution in the oceans, most fish contain heavy metal elements and radioactive substances. That's why it's so important to choose a pure source of omega-3. Puritang green vegetable omega-3 is made from purslane and perilla seeds, which are rich in nutrients and minerals, especially vitamins A, D, E, calcium, and iron. With natural processing and no harmful chemical additives, it has more than 90% concentration of omegas 3, 6, 7, and 9. It effectively improves brain power and is beneficial to the heart's health. Puritang omega-3 does not smell of fish and contains no pollutants, so both adults and children can safely and easily consume it over a long period of time. Puritang green vegetable omega-3. Greener, healthier, and more effective. Visit puritang.com to learn more.
Just like all of you, I had problems sleeping. I had tried every pillow out there and nothing worked. I'd flip-flop all night, use my arm for support, and fall asleep, or I'd wake up with a sore neck or maybe a headache. Well, quality sleep comes from keeping your neck straight at night. You have to fill in that space between your head and your bed. That's why I invented MyPillow. MyPillow's patented fill adjusts to your exact individual needs, and it doesn't matter if you sleep on your back, stomach, side, or any combination of all three.
When I got MyPillow, I'm asleep almost immediately. I stay asleep at night, and I wake up more well-rested in the morning.
So go to MyPillow.com or call the number on your screen. Use your promo code to get Classic King MyPillows for only $19.98. Queen size just $18.98. Standard Classic MyPillows only $14.98. That's right, only $14.98. Plus all orders $75 or more ship absolutely free.
My dad was a farmer, and when I saw him on a horse, the guy was bigger than life. One of the things that he had a hard time doing was showing the emotion. Maybe it was because the way he was raised, or believing that men provide and they don't struggle. But we all struggle. I want to show emotion to my kids. I want them to know when I'm happy, I want them to know when I'm sad, and I want them to see me working through things. The biggest reward I get from being a dad is watching my kids accomplish a goal, watching them light up. Nothing brings a bigger smile to my face. So I make my kids a priority. Whether it's hitting a baseball, a dance rehearsal, you name it, I'm there. They're gonna remember that they grew up loved. Be brave. Be there every day. And allow your kids to know that it's okay to struggle. That even dad doesn't know the answer sometimes, but we're gonna figure it out together.
Continuing with the fires in Los Angeles, the Pacific Palisades area is one of the most expensive neighborhoods in the U.S. It's home to Hollywood A-listers and multi-million-dollar mansions. Ahead of this week's disaster, its insurance costs were among the most affordable in the country. Here's a look at how the fires may impact homeowners' insurance in that region.
They're the most destructive wildfires ever seen in Los Angeles, and that has insurance companies braced for a big hit. JP Morgan on Thursday estimated losses to the sector could hit $20 billion. That's double its estimate from just a day before. Ratings agency Moody's also puts the probable losses in the billions of dollars. It says the number is inflated by the way the fires hit neighborhoods like Pacific Palisades and Malibu, which are full of high-value homes. But experts say many properties may not be covered by fire insurance. Homeowners have found it increasingly hard to buy cover in disaster-prone states, with many insurers pulling out of the market. In California, regulators had until recently capped prices for insurance. That limited annual increases, but led many providers to flee the state, saying they couldn't make a profit there. Now the wildfire disaster is set to make the problem worse, with premiums likely to soar and more companies refusing to provide cover at all. One expert said it would be hard to offer affordable policies in hard-hit areas like Pacific Palisades, which would remain at high risk of future fires. History shows what can happen. In hurricane-prone areas like Louisiana and Florida, insurance premiums more than doubled following big storms in recent years. On Thursday, Germany's Munich Re, the world's largest reinsurer, said insurers saw losses from natural disasters hit $140 billion in 2024, one of the highest numbers on record.
President-elect Trump plans to appeal his New York criminal conviction after this morning's sentencing. He was found guilty of falsifying business records related to payments made to adult film actress Stormy Daniels.
NTD's Chris Beers joins us for the latest on the case. Chris, good to see you. Update us on this unprecedented set of circumstances.
Guys, President-elect Donald Trump does plan to appeal his criminal conviction. He was sentenced with that conviction around 9:30, 10 a.m. just this morning. He appeared virtually in court next to his attorney, and this is, of course, for the New York criminal case in which he was found guilty of 34 criminal counts just this summer. This was related to falsifying business records for payments made to allegedly cover up statements of the adult film actress Stormy Daniels before the 2016 election. The court did release audio playback of what happened inside the court today. Here's Trump on the case.
This has been a very terrible experience. I think it's been a tremendous setback for New York and the New York court system. That legal fees or legal expense were put down as legal expense by accountants. They weren't put down by me, they were put down by accountants.
There's so much that's unprecedented with this case, guys. President-elect Trump is the first former president to ever be sentenced in a criminal case. Of course, he's also the first president-elect to ever be sentenced like this. And in about 10 days, he will be the first president ever to walk into the White House as a convicted felon. So a very significant case and sentencing appointment today for American history. What's interesting about this case is that he actually won't face any penalty. He's being sentenced on what's called unconditional discharge, meaning there will be no jail time, no fines, there won't be any kind of community service or anything. Trump commented on the unprecedented nature of today's sentencing. Watch.
I'm the first president in history that was under a gag order where I couldn't talk about aspects of the case that are very important. This has been a weaponization of government. They call it lawfare. Never happened to any extent like this, but never happened in our country before. It was done to damage my reputation so that I'd lose the election, and obviously that didn't work.
So Donald Trump obviously unhappy with the outcome of this case. Judge Juan Merchan did weigh in on the unprecedented nature of this case, saying that while there were a lot of unprecedented things that happened outside of the courtroom, what happened inside of the courtroom is the same thing that goes on with every other case that this court sees, guys.
Trump had been fighting this sentencing date, even though he knew he likely wouldn't face any penalty. The Supreme Court denying his request to have the sentence delayed late yesterday. What happened with their decision?
Yeah, so Trump asked a New York appeals court, the New York Supreme Court, as well as the U.S. Supreme Court to delay sentencing in this case. He did so on grounds that it could damage the office of the presidency, and also that some of the evidence used in this case was official acts that he did while president. And of course, the Supreme Court this passed this past summer ruled that presidents do have immunity on some official acts. He was denied his request to delay by all three of these courts. The latest, of course, being the Supreme Court, as you mentioned, just last night releasing a statement, a brief one-paragraph statement saying that he can appeal this conviction in the New York State court system. So, at this time, there's maybe no need for them to rule on this. And then the sentencing, won't hinder him as president because, again, there's no penalty here. It was a 5-4 decision with Clarence Thomas, Samuel Alito, Neil Gorsuch, and Brett Kavanaugh dissenting. And, of course, as I mentioned earlier, the president-elect does plan to appeal this decision, but it's likely any appeal, any further proceedings in this court will take place while he is president, guys.
All right, Chris, reporting from Manhattan, thank you very much.
And for round-the-clock original news coverage, watch us live at ntd.com/live or download our NTD app.
If you have any feedback, please email us and be sure to stick around for NTD Newsroom at 2 p.m. Eastern Time. We'll cover more stories from the U.S. and around the world. Thank you for watching.